Everyone, I think my watch says 2 o'clock, so I think we're ready to begin. As we always do here at the Superior Court, we ask all of you if you would like to please stand and join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. And at the outset, we're going to ask you all to join us in just a few moments of silence in recognition and memory of all those who have lost their lives the last couple of days around the world. Well, again, thank you very much. My name is Jack Piniella. I am the President Judge of the Superior Court, and my co-chair, who I could not have done this without, is Judge Megan King, and I can't say enough nice things about Judge King, all the help she gave to us. At the outset, we would like to thank the PBA, whose idea this was, and approached us saying, would you like to have a symposium? And we jumped at that. And the first hour, they asked us to do a 3-hour symposium. But we weren't able to do it because of the pandemic 2 years ago. Technically, our 125th anniversary was 2020. I guess that's a little more than 2 years ago. But we decided to celebrate it today. So the first hour of our program is going to be celebrating the 125th anniversary, 1895, of the Superior Court. And all of you should have received these wonderful booklets. Notice I say wonderful because I wrote portions of it. But I also thank John Hare for joining me in the drafting of this booklet, which really is a detailed account of the experiences and development of the Superior Court. The other thing, hopefully, you received when you walked in, you know, in court, things are very professional. It's very quiet. Everybody's very well-mannered. We wanted to thank all of you for being here, and frankly, we wanted to do something a little goofy. So we got all of you, Judge King and I, baseball caps celebrating the 125th anniversary. So for those of you that golf, we expect to see these out on the golf course. At this time, we would like to invite the president of the PBA, Michael McDonald, to come up and give us all a greeting. Mr. McDonald?
Thank you, President Judge Piniella. Thank you, Judge King. Distinguished jurists, preeminent practitioners, and special guests. It's really my honor, on behalf of the Pennsylvania Bar Association, to welcome everyone here today at this 125th anniversary of the Superior Court, and to celebrate our lives together, our lives in the law, and the wonderful profound effect we've had over the last 125 years. I just want to tell you that as I think about this, I think really, as well as the Superior Court, the Appellate Advocacy Committee of the Pennsylvania Bar Association deserves a round of applause. And I just want to cite co-chairs who are here today, Carl Myers, Virginia McMichael, and Maureen McBride. Yes, so could we please have a looking for everybody. Myself, I do not do appellate work, but I can tell you, I think I have a unique experience because I know, sitting front and center, how the appellate court and the Superior Court have made such an impactful justice difference to every citizen in the Commonwealth of Pennsylvania. How the clear and reasoned opinions in the Superior Court have made a difference for all lawyers who are practicing and filing claims and resolving cases. How the clear and very, very well-defined Superior Court decisions have aided the 466 common pleas judges to do justice and to resolve conflicts every day. And by that, by applying that law, every day I see it throughout the counties, we are instilling a belief in the justice system to every citizen in Pennsylvania. And I just want to say thank you to the Superior Court for that. But as I think about the Superior Court, and I think about 125 years ago, 1895, I think it was a year before I was born, according to my son. But, you know, it was the same year that the PBA was founded. And together, we have been your other partner for really 128 years. And we are so happy to share in your success, to see the storied history that you have, to see the success of the present, and to see the future plans for incredible success. And I would just like to end it by saying there was a practicing attorney who was born in Kentucky, went over to Illinois and was practicing a little, and had a statement that is attributed to him, and that is that the rule of law upon which democracy is based is not the absence of conflict. It is the presence of justice. And thank you to the Superior Court for doing justice. I appreciate it. Thank you. Thank you. And on behalf of the PBA, President Judge Padella, we have an honorary proclamation, which, to save everyone, I will not be reading here today. But suffice to say, it has wonderful things to say about the Superior Court, and I thank you all for being here.
Thank you very much.
Thank you.
Well, we need to say thank yous to just a few people before we start the program. I can't tell you how wonderful it was for Judge King and me to work with Stacy Thomas, the program manager for the PBA. What a great job. Stacy, are you in here? Thank you, Stacy, very much. And Mike just took one of my introductions away, but I was going to thank Maureen McBride and Carl Myers, who I worked very closely with during the preparation for this. I've already mentioned John Hare's name, who helped us with the booklet. And another great person is Kyle Kaufman from AOPC, who assisted us in doing a few of the videos that we're going to be showing today. Again, great people to work with. At this point, I'm going to ask Judge King.
Thank you so much. It's an honor to be here. I am proud to introduce some of our special members of our court. I'd like to introduce the court administrator for the Commonwealth of Pennsylvania, Andrea Tuominen. I hope I pronounced that correctly. Thank you. Also, Teresa Ficken-Sachs, attorney for the Supreme Court. Chris Nace, the executive administrator for the Supreme Court. Jennifer Traxler, who is our executive administrator for the Superior Court. Ben Kohler, who is our prothonotary. Phil Yoon and Catherine Shelley, who are chiefs of staff of our Central Legal Service. Dolores Bianca, who is our reporter. And Peter Johnson, who is the head of our computer systems. Thank you so much.
Well, we're finally ready to start first part of our program, and we wanted to inform all of you a little bit about the history of the Superior Court. So at this point, we're going to go to the video. Did they hear me? Hi, I'm Jack Piniella. In 1895, the Pennsylvania General Assembly established the Pennsylvania Superior Court to assist the Supreme Court and hear appeals from the trial courts of the Commonwealth. Although the court was established in 1895, the roots of the Superior Court started years leading up to its creation. From tentative origins, the Superior Court would emerge into a renowned judicial body that would confront and resolve some of the most difficult issues ever presented to the American judiciary. These included the complexities of Pennsylvania's headlong industrialization, 2 world wars, the misfortune of the Great Depression, the expansion of tort litigation, and evolving notions of fairness and justice in the realms of family and criminal law. Through its work in these and many other areas, the Superior Court has developed a prominent national reputation and significantly developed and improved the rule of law in Pennsylvania and our country. The movement to establish the Superior Court gained momentum in the 1890s, finally coming to a head on June 6, 1895, when a bill was passed by both chambers and signed into law by Governor Daniel H. Hastings, to be later known as the Superior Court Act of June 24, 1895. The Superior Court was originally composed of 7 judges with statewide jurisdiction. The judges always sat together on a circuit around the state. The judges were to be elected for a 10-year term. The judges were granted no original jurisdiction, but had appellate jurisdiction in civil and criminal cases. The court was permitted to establish the times and locations of its sessions, but it had to meet at least once a year in Philadelphia, Pittsburgh, Harrisburg, Scranton, and Williamsport. Eventually, the Supreme Court of Pennsylvania, citing the heavy volume of appeals, exercised its constitutional supervisory powers and permitted the Superior Court to begin sitting in panels of 3 judges. The most senior judge would preside at these 3-judge panels. This policy remains today. You will hear later in this program about milestones in the history of the Superior Court involving diversity and leadership. In 1998, the Superior Court moved to its new home from Philadelphia City Hall to the Penn Mutual Building in Philadelphia. The courtroom was designated as the Founders Courtroom, since it overlooks Independence Hall and Washington Square. The conference room attached to the courtroom was eventually named in honor of former President Judge Stephen J. McEwen. As the Superior Court entered the 21st century, the court initiated a number of policies and programs designed to better serve our citizens and enhance the ability of our judges to participate in court decisions. During the year 2020, the Superior Court faced another major challenge, and I know this one well. The spread of the coronavirus at the beginning of 2020 created significant public health concerns and consequently affected the daily operation of the Pennsylvania court system. Internally, the Superior Court reacted promptly to ensure the safety of all staff, but we kept the wheels of justice moving by utilizing remote arguments. The court continues to be one of the busiest appellate courts in the nation, with 15 full-time commissioned judges assisted by senior judges appointed by the Pennsylvania Supreme Court. Judges gain seniority by length of continuous service on the court, with elected judges receiving seniority over those serving by appointment. The president judge is chosen by election of the court to serve a 5-year term. In closing, I would like to refer to a proclamation issued by the American Bar Association, which saluted the Superior Court. Quote, "For its leadership, commitment, and creativity in creating programs to enhance public knowledge and confidence in the rule of law and our justice system." It is with great pride that my co-chair, Judge Megan King, and I are members of the Superior Court. With that, we're going to turn now to our live speakers. And they always say video adds 10 pounds to you. But I think it was my appetite that added 10 pounds to it. Our first speaker is Judge Alice Beck-DeBow, who's going to talk about her mother, Judge Phyllis Beck, who was the first woman to sit on the Superior Court starting back in 1981. Judge DeBow?
Oh, okay. Yes, so my mother was planning to come today, but she had a conflict, so I am filling in for her. Before I do talk, just a brief introduction about my mother. I do want to really thank Judge Piniella and Judge King for putting this together, and especially Judge Piniella, who is creating and memorializing the work of Superior Court for the past 150 years. He's creating a website, he is developing videos, he is working on pamphlets, he's working on books. And Judge Piniella, to me, as a member of the court, and I'm sure I'm speaking for everybody else, the other judges, lawyers, and the staff, your efforts to memorialize Superior Court is incredibly important and not easy, and we really do appreciate all your efforts and what you're doing. So anyway, all right, so back to my mom. So I actually, for those of you who don't know me, I am currently a judge on Superior Court, and my mother and I like to say we're the only mother-daughter pair on any appellate court in the country. But let me just briefly introduce a video. I interviewed my mother. This is for the website that Judge Piniella is working on during COVID. And she does talk about what it was like to be the first woman on Superior Court. Let me just give you a little bit of timing information so you can put it in context. I do remember I was in college. This was probably about 1979, 1980. I remember my mom calling me on the phone and telling me that there were some openings on some appellate court and she was going to try to be on the appellate court. And I was like, oh, that's kind of cool. We didn't really know judges. I was just sort of surprised that's what my mother was doing. But that's what my mother set her mind to do. And so in 1980, when the court was expanded and there were 8 new judgeships created, my mother was appointed by Governor Thornburg, and she was then elected in 1983 and served on Superior Court until 2007. So we're now going to watch the video, a portion of the video of where I'm interviewing my mother about what it was like to be the first woman on Superior Court. When our this is just a portion of the interview, so let me give a plug for the website when it is finally up. It's a longer interview, and when we get the website going, if you're interested, you could see the whole interview. So with that, if you can play the video of my mother, Phyllis Beck, and me. Once you were confirmed, it was only for a 2-year term, and then you had to run statewide for a 10-year term.
Right.
And can you talk a little bit about what that was like and how you convinced voters who had never supported a woman candidate for an appellate court, and how you connected with them and was able to convince them that a woman belonged on an appellate court?
Well, if you're running for office, as all judges in Pennsylvania know, if you're running for office, you have a product to sell, and that product is you. So you have to package yourself in a way that's acceptable to the voters. And I realized that the way I had to package myself as a woman was I had to package myself in a non-threatening way. I had to package myself as a mother of 4 children and a wife who happened to be a lawyer with a pretty good record. And I realized that was the way to go, because the year before, just a brilliant, she was a common pleas court judge, just a brilliant common pleas court judge from Philadelphia, ran for the Pennsylvania Supreme Court and was defeated. And I realized she was defeated because she presented herself as really kind of an Ubermensch. And she would sit on the platform in a political meeting smoking with a cigarette holder. And I figured that's not the way Pennsylvania would vote for a woman. And fortunately, I guessed right, I packaged myself right. And when I spoke to a lot of bar associations, made a lot of speeches, but at bar associations, men would come up to me and ask me questions, not about their wives, but about their daughters.
So you could see the tide was moving, that the men saw you as a role model for their daughters.
For their daughters, yes.
All right, so now to just focus a little bit about your time on Superior Court. When you finally arrived on the court, you're the only woman out of 15 judges. What was it like to be the only woman on the court?
Well, I must say my colleagues and the staff were very generous and very helpful and very welcoming. So I've got nothing but good things to say about all of them. However, occasionally a lawyer was not that. I remember one of my first cases, which was in Philadelphia, and the issue was property distribution upon divorce. And this lawyer, who I had only known by reputation, begins his argument by making a motion for me to recuse myself. So I said, why do you want me to recuse myself? And he said, because you're a woman and I represent the man and you couldn't be fair. So I thought, if he was representing the man, would he ask the men to recuse? And I realized what a stupid motion that was. And so I very rapidly just denied that and went on to hear the case, and I think I was fair.
Now, on a lighter note, you're serving on a court with all men. Any issues about facilities at the court?
Oh yes, yeah. When, as I told you, especially the staff and the judges, they were very hospitable to me. And I was sitting in Pittsburgh, in Allegheny County, at the courthouse, and the court cry of Pat was just dear. He just tried to do everything to make me comfortable, but he forgot to do one thing. He forgot to make arrangements for the bathroom for me. And so there was a lot of going around and shuffling. And I said, Pat, just sit down. And I went into the men's room, put occupied on the sign, as a sign on the door. And as I say, I liberated the bathroom in Allegheny County.
So over time, more women came onto Superior Court, although the next woman to actually join you on Superior Court was Judge Kate Elliott, who didn't join until 1989. And then I guess during the 90s, a lot more women were elected to Superior Court. So by 2001, there were 6 women judges on Superior Court. Did you feel any difference as there became much more of a critical mass of women on the court?
No, I think the difference really came not from the gender of the judges, but from the social upheaval that was going on in the 80s and 90s. In the 80s, it was the beginning of no-fault divorce. It was the beginning of lesbian or homosexual families adopting children. There were advances in vitro fertilization and also in surrogacy. So there was the social upheaval that we see today really began very strongly in the 80s. So no, I really, the women I served with were intelligent, forward-looking, and were involved in the judicial aspect of the social upheaval as I was.
Very much. Judge Dubow, it is my distinct honor and pleasure to introduce two more incredible women and jurists. President Judges Emeritus, Kate Ford Elliott and Susan Gantman, who will share with you their perspectives as being the first and the second women to be elected President Judge of the Superior Court.
Thank you, Judge. Just going for just a second to comment on Judge Beck. When I was employed by the court at that point. I was the administrative assistant to Bill Sircone when she came on board. And just watching how smart she was, how strong she was, and yet how gracious and kind she was with everyone she dealt with. It didn't matter if you were an employee or a colleague or a lawyer. Those are great qualities to have as an example in a judge, and I've always been very, very grateful that I had her as a mentor. Now, by the time I was elected president judge, I had either served the court as an employee or as a judge for 28 years. It took me a long time to get from the standing position to the seating position on the bench. I'd seen the terms of 8 president judges go by, so I had a pretty good idea of those I wanted to emulate and those I did not. Now, one PJ I greatly admired is here with us today, and he was my immediate predecessor, Judge Joe Del Sol, and he taught me a lot, and I'm very grateful to him for that. I think because of my long history with the court as a staff member, I wanted to be sure that I always considered the impact of my administrative duties and decisions on employees of the court. Personnel matters are a huge responsibility of that office, and in some cases, I needed to be a shield between the staff and the judges. Now, I know some of you are going to find this very hard to believe, but judges can be real bullies when they want to be. And that's something you have to keep in mind, and we'll blame them. I mean, they're elected statewide by the people of Pennsylvania. They come on the bench, they run their own chambers, they hire their own court personnel, and they make their own decisions. And so therefore, it has to be expected that they'll be sometimes a little bit difficult at times. I also recognized, because I had seen so much of it in the court over the many years, the most important responsibility I had was to the collegiality of the court. I had long observed that the only way the court can successfully operate was to make sure that lines of communication were always kept open. I watched one of my mentors, Bill Sircone, who I had served as administrative assistant, tread some very difficult waters during his time as PJ. It was a time when the court was expanded in 1980 from, as Judge Beck was talking about, 7 judges to 15 judges. And we were going from sitting as a continuous court in bank to panel sessions where 3 judges would sit. And it was also the same time, as Judge Beck just mentioned, that the no-fault divorce law, as one example, came into being. And what was amazing was the very first court in bank that Judge Sircone held, for obvious political reasons, he had all 15 judges sit on the court in bank. And as you can imagine, that was literally a nightmare. It took months to get a majority decision, get a dissenting decision, and try to convince all the concurrences that they needed to go away. That was a very difficult time. But what I watched Bill Sircone do is even when you'd have the most strident individuals on the court who would clearly want to have their own way, he would always force them to talk. And he'd force them to talk to him and then to talk to whoever the adversary was at the time. And I learned a lot from that because I saw him resolve questions that I actually, as a practical matter, never thought he would be able to do. And this came this became very important to me since during my tenure as president judge of the court, by my count, 10 judges came on board and 8 judges left. Now that means that you have a tremendous amount of flux in a court. You have chambers, you have judges coming on. Some of them have no clue what they're going to be doing. Some of them have been trial judges. And trial judges have this distinct idea that when they make a determination or a decision, that's it. And they don't realize that they've got to work it out with 2 other votes if they're ever going to be able to render a decision on the Superior Court. So it was a time of great flux. One of the things I always thought was interesting, though, is with the older judges on the court, the ones that I started out with, they had a sense that, and they were all men, that being a judge was who they were and not what they were. And what I noticed, quite frankly, as more and more women came on the court and some younger judges, is that all of a sudden a judge was what you were. It wasn't who you were. And so I know in my experience, because I was a mother and I went on the bench with my son was 3 years of age, so I was raising him at the same time. So I always had 1 foot in chambers and 1 foot at home taking care of my son. And I see this in women who are professionals here. They know how important it is to have something else to be involved in besides just your work. Either it's volunteering for something, it's a hobby that you truly love, or it's being involved in a bar association. That's very important. And I just want to take a minute to do a shout out, and this is dedicated to you, Mr. President, to the PBA. When I was president judge, it was at a time when there were full-scale campaigns being mounted to unseat judges, particularly those standing for retention. And were it not for the unified effort of the Pennsylvania Bar Association, the Supreme Court, at that time it was Justice Castile, and myself, we went all over the state. We went to every single Bar Association meeting we could find to try to convince people how important it was for the stability of the law that we maintain experienced judges on the appellate courts of Pennsylvania. And certainly we were diverse enough. On Superior Court, our judges were from all over the state. But I have to tell you, and I think that one of my best memories of being the very first female PJ was one day I received a note from Deborah Todd, my colleague, now Chief Justice Todd. And she jokingly asked me to order small individual fans for each of the women judges to have on the bench. There were 6 of us at the time, and we were all of a particular age. And therefore, it certainly made a great deal of sense. You know, it can get very, very warm sitting in those robes under the lights. And with that, as they say, have been saying a lot on TV these days, I'm going to yield any remainder of my time to my dear friend, Judge Susan Gantman.
Just to speak about Deborah Todd sending us a little note, the Superior Court is known as a hot court. That means that we have read the briefs, that we have read the trial judge's opinion, and that we are prepared and ready to go. So Judge Todd at the time sent around a card that said, do you mind shutting the window? Do you mind turning the air conditioning up? Do you mind turning the air conditioning down? It was a conversation regarding hot judges. So, being a woman on the Superior Court is easy now. There are many of us. It's really not an issue. Those of you who know me, I am very no-nonsense, and I have a very good sense of humor. So that you have to be prepared to have discourse and conversation. It was my honor and privilege to serve as the president judge. I was elected by my peers in January of 2014 and served for 5 years. So I have 2 children who are now grown, and they were in college at the time, and my daughter said to me, so why are you only serving 5 years? I said, it's constitutional. That is the time period which you're permitted to serve. I want to thank President Judge Piniella and Judge King for organizing this great seminar and for asking me to speak today. And I want to thank the Pennsylvania Bar Association. We have had a long history with the Bar Association, and we are grateful for your work. During my tenure, I asked the Supreme Court for permission to have all of our lawyers' dues paid to both a local bar and the Pennsylvania Bar Association, so we increased our ranks of our lawyers who are working with you. My race, 2003. Let's go back in time a little bit, and there was an opening on the Supreme Court, which Justice Baer won that Supreme Court race, and there were 3 openings on the Superior Court. It was an interesting race. Nothing much was happening. We were running around, traveling all over the state, and on Election Day, I anticipated, and it never occurred to me, I would not win. I am from Montgomery County. I was at the Montgomery County election, headquarters. They were counting the votes. Everyone in the county had finished their race at 10 p.m. My secretary had a cake in the car for me. It was a giant cake that said, "Congratulations." The cake never left the car. At midnight, I was down by 2,200 votes. That was it. My campaign manager left. He had decided I had lost. I went to sleep. My son called me at 6 in the morning, and he goes, "Mom, you're up by 800 votes." I said, "You're kidding." He goes, "No." I said, "Has the T come in? Has the Republican T come in?" "No." I said, "Has Philadelphia filed their votes?" 92% Philadelphia's in. I said, "I've won." He said, "You've won?" I said, "Yeah, it's going to be weeks. We're going to be counting these votes for weeks." So the other 2 judges had won by midnight. Jack Piniella and Seamus McCaffrey. Their votes were in, they had won. John Driscoll from Westmoreland County and I were neck and neck. Votes here, votes there. We finally got Carbon County, and I won Carbon County by 6,000 votes. I said to my son, "There aren't 6,000 votes in Carbon County, it's an error." So we went back and forth. I was from Montgomery County, and I had worked with 12 judges and also the governors in running races as part of the Republican committee in Montgomery County, so I knew every single county. So we have a bulletin board set up that morning. We have all the votes set in. I didn't go to work Wednesday. The cake was still in the refrigerator. I was an attorney at Cozen O'Connor at the time, and it went on and on and on. I was declared the winner on January 2, 2004. I won by 49 votes. Governor Rendell did not want to issue my commission, but Judge McCaffrey and Judge Piniella were furious because the commissions were bundled. So they couldn't get their commission until I got my commission. And the 3 commissions actually were issued that day, and I received it in the mail Saturday morning, January 3rd. Judge Del Sol was the president judge of the Superior Court. He and I were on the phone. Judge McCaffrey had his ceremonial installation on Friday, January 2nd, and I told Judge Del Sol that I wanted him to swear me in. And he said, and he was on his way to the airport. And I said, "I'll meet you at the airport." He said, "That's great, but you don't have your commission." He left for Florida, and he said to me, "If your commission comes Saturday morning, you get sweared in on Saturday before they pull it." Saturday morning, my commission was received. I called Justice Newman. She lived right near me. I drove over to her house with my family. Justice Newman swore me in, and I started work on Monday. The closest statewide race in the country since the Civil War, when they have been counting it. So my colleagues on the bench thought it was very funny, and they called me landslide. But as I say, it doesn't matter if you win by 1 vote. Your name is judge. As president judge, I was fortunate to build on the past successes and to continue to build a strong management team for the court. We work with 15 commissioned judges, 5 senior judges, judicial chambers, law clerks, CLS, and staff. No matter what you do, no matter what you say, if you say nothing, 20% of the people are against you. You must take that with a grain of salt. We tried to build consensus. I want to thank all of the members of the Superior Court, and particularly the judges, for your time, your service, and your talents. Our judges teach CLE courses for the court, for the trial judges, for the PBA, and other organizations. Thank you. The Superior Court is fortunate that judges and staff have chosen public service. As a president judge, your job is extremely complex. I call it consumer contact, complaints, and resolutions. Everyone calls you to complain. Everyone. It's like unbelievable. Worse than my children. I said, you know, it's worse than a second grader, but I think you're giving second graders a bad rap. We plan the calendar and we assign cases. It is truly done anonymously and on a wheel. Since the computerization of the case management system, they're rolled out. When I first started as a judge, because my election was so much up in the air, people didn't know if I'd won or I hadn't won. And in February 10th, I started getting Valentines from prisoners. I mean, not like one Valentine or 2 Valentines. I got about 40. And I thought, and the Valentine said, "Dear Judge Gantman, please look at our case." And then they would tell me what their case was. And my staff didn't want me to open these Valentines because you don't know what's in them. So all the Valentines went to security. And they were laughing. They said, "We cannot believe these prisoners are sending you Valentines." But, you know, what can I say? The cases are assigned anonymously and spun out. The judges sit in 3-judge panels, and they're assigned randomly so that you have to sit with every single judge on the court. And I will say that some of us did not get along with other judges on the court. And it was important that you could disagree with a judge, but as Judge Del Sol told me, you can disagree, but do not be disagreeable. And I think that the collegiality which President Judge Emeritus Kate Ford Elliott spoke about was so important and really prevalent on our court. During my tenure, our management team, with recommendations of our judges, initiated many programs. I was a member of the national organization, the Council of Chief Judges, and this is very important. It's a national organization, and they're president judges from every intermediate appellate court. Judge Del Sol was on that committee, and then Kate Ford Elliott was on that committee, and President Judge Emeritus Kate Ford Elliott became president of that organization. Judge McEwen had served as president of that organization, and he encouraged me to go and to make sure that I participated. In fact, not only did he encourage me, he put me on 3 committees. But that was very important because what I learned at the very first meeting was the catastrophe of Hurricane Katrina. Hurricane Katrina wiped out the New Orleans court system. They were down for close to 2 years. And when I heard that, I came back with an extremely talented IT department and the help of AOPC and the Supreme Court of Pennsylvania. We started a 5-year plan for remote access to our courts. It started out with the Log Me In, and you know, the people in our IT department were extremely brilliant. We had remote access in the state of Pennsylvania and the Superior Court long before anyone else did. And the Supreme Court did make fun of me, had little things on my name that said, log me in, you know. It was when technology was really just becoming very popular. But who knew that that primitive system, which was then expanded upon, would become the immediate access during the pandemic. The Superior Court and Judge Piniella and the entire judges should be so proud because it was a turnkey operation and we were up and running within 2 weeks. We were also fortunate to work with the Supreme Court because we had set up a policy that you could, and it was kind of funny when we were working on it, that we had emergency e-filing. And we had a whole protocol set up in the event there was a cyber attack. Particularly, I was concerned with Philadelphia being attacked because their system was very high-tech at the time, but subject to some flaws. So that if you had an emergency filing, you would be able to file it with the Superior Court, and then we could transfer to any county in the state in the event of time-sensitive documentation. We presented seminars and educational programs for AOPC and our employees, how to handle harassment. And as President Judge Emeritus Kate Ford Elliott said, personnel was really one of the hot topics. We ran a seminar for our judges, and I was laughing because one of the male judges said to me, "This isn't applicable to me." I said, "No, this is applicable to you. You cannot harass your staff." He goes, "We have immunity." I said, "No, not from harassment." And it was interesting because there was an educational process which we completed. You don't want a hostile work environment. You want to understand it. We also ran seminars for people to understand retirement, to understand their pension, and to understand their benefits. We worked on building experiences of the prior president judges, and I think Justice Stevens started this, or maybe even went before that, where we traveled all over to different courts and different venues to hold Superior Court sessions at law schools, at counties, and for the general public. That's very important for education because, as most people say, what court are you on? What is the Superior Court? We established a comprehensive security department, and with trained police officers with Act 205 certifications, laser training, and CPR, and our security team worked closely with the Supreme Court. We provide training in active shooters, CPR, and safety plans, so that the Superior Court is a very busy court, and the management team and the judges and the president judge really have a full plate. It has been a great pleasure to work with the Superior Court and our partners, both the Pennsylvania Bar Association, the Philadelphia Bar Association, Allegheny Bar Association, Montgomery County Bar Association, all the other counties. I don't want to preclude any, but our 3 largest counties and the state give us tremendous support. I want to thank you for coming today, and I want to thank you for having us.
Thank you very much. Just was wonderful working with Judges Kate Ford Elliott and Susan Gantman. Well, my heart dropped a couple of years ago when Judge Maureen Lally Green announced she was withdrawing her name from retention. We enjoyed, she's such a wonderful colleague. But she had a great life after the Superior Court, and we've asked her to come and speak about that today, what it was like to become the dean of a major law school following her service as a judge. So, Judge Lally Green.
Thank you, Judge Piniella, and thank you, Judge King, and all of the staff that helped make this happen today. I have to acknowledge that I'm going to focus a bit more on leadership and how my colleagues taught me so much about leadership, because there is life after the Superior Court, and I called it, I couldn't have done the latter portion of my life if I hadn't had the experience of the Superior Court, because I learned about leadership, not just management, but how to be a leader. And so I thought I'd focus on those points today. First of all, the great leadership I had of my president judges. I came on the bench in 1998 and was appointed by Governor Tom Ridge, and so I came on in June of that year. and then ran for office in 1999 with a judge then, Deborah Todd, who became a judge with me, and then she is now our Chief Justice. And it was a great, wonderful campaign, and I became very close with Judge Klein, who was my running mate, way at the other end of the table. And so it was really great seeing him today. But once I got on the bench, I immediately became aware of, wow, this was a very special, honorable position. And the first person I met actually was your mother, Alice, Judge Alice, sorry. Your mother, and Phyllis Beck was so welcoming. Oh, by the way, I had known Judge Kate Ford Elliott for a long time back in Pittsburgh, but Judge Phyllis Beck welcomed me, and I never felt unwelcome in any manner. But the point of this is that then I was walking to the brand-new Superior Court in the Penn Mutual building, and I got a phone call from my current PJ, and that was Judge Stephen McCune. And he says, I'm going to walk you to the court. And I said, Judge, you don't need to do that, or PJ. We always called the president Judge PJ. I don't think you need to do that. I think I can get there. He says, no, it's your first day. You're going to have somebody walk you to the court. And indeed, he came, picked me up at the hotel, and we walked to the court. And it was just the first indication I got of the incredible leadership that Judge McCune showed. And he was my first PJ. Then a few years later, my second PJ is sitting right next to me to my right, and he too taught me so much, and it was a delight working with you for 4 or 5 years, all those wonderful years, my fellow friend from Pittsburgh. And then my third PJ was, of course, President Judge Kate Ford Elliott, again, a great leader. So fast forward, I did a number of years working locally with the Diocese of Pittsburgh, and then I got a phone call from Ken Gormley. Now, everybody in this room knows Ken Gormley, don't you? Yes. And Ken was the newly appointed president of Duquesne University, and he had been the former dean of the School of Law. And he said, would you like to come and be dean? We need a dean. And I said, I've never had a position in that way. And he said, I think you can do it. Apropos the leadership values and experiences of the earlier time all of a sudden became very important. So these are the 3 takeaways I would have from the experience of the Superior Court that I was able to implant in the work of the dean. The first would be the incredible learning experience of the court in knowing the facts, knowing what the precedent was, knowing what the issue is. Just that discipline was so effective in working with my colleagues, trying to get it right the first time, doing the right thing right the first time. I would say the second takeaway was one that we've heard a couple times now this morning, or this afternoon, and that is the value of collegiality. And embedded in collegiality is the value of values, having something that is holding you all together. And I call that tone at the top when one is in a leadership position. What is it that you have a lot to accomplish? How is it you're going to accomplish it? And what is it that binds you all together? Because that's what is really important. And that then led to the third point I'd like to share, and that was this: the mission. Always being cognizant of the mission. Here at the court, it's pretty clear. We're all lawyers. Some of us are judges or former judges. I see a colleague actually in the audience. I wanted to make a shout out to Judge Gracie. He's in the audience. So we knew what our mission was as judges. But when you go to a school like a law school, the mission is what? It's one thing. It was serving students so that the students could serve others. That's what the whole gig was at a law school, was serving students so they knew how to serve others in the practice of law. And that became the paradigm for our faculty and for all of the work we did in creating opportunities for the students. And frankly, I don't think I would have grasped the value of those 3 items had I not served on the Superior Court. So with all of that, I just hearken back to something said very earlier about Abe Lincoln. And one often asks different people, what made them a success? And Abe Lincoln was asked what made them a success, what made him a success. And he said to the person, I am a success today because I had a friend who believed in me. And I was afraid of disappointing him. And I feel like that is what binds us all, is we all have become friends. And friends don't need always to agree. They can disagree as long as they are not disagreeable. And isn't that what we all do in the law, in the practice of law, when we work with our colleagues? So I thank Judge Piniella, President Judge Piniella, and the rest of my colleagues on the bench, here and not here, for always being that friend who was supportive and believed in me. So thank you.
Thank you so much for sharing your perspective. Thank you very much for your sharing of your perspective and your experience. Our next speaker is President Judge Emeritus Joseph Del Sol, who will share with you his experience in returning to the practice of law following his years of service on the court.
Thank you, Your Honor. I understand from the President Judge Piniella that we are running a little long, so I'll shorten my time. Since leaving the bench, I've noticed a few interesting things. My jokes are no longer as funny as they were. Lawyers are generally busy when I call, either on another line or out of the office. And while on the bench, parking at courthouses throughout the Commonwealth was not an issue. Now it is. On a serious note, I was amazed at how much the internal office practice of law changed between the time I was in practice and returned to practice. Before going on the bench, high tech was an IBM Selectric typewriter with a white ribbon to correct mistakes. Lawyers would dictate briefs and pleadings on a recording device, and secretarial staff with the dreaded carbon paper would type up the pleadings. Law libraries are also a thing of the past, replaced by electronic research and brilliant young legal minds to review the issues and draft the memorandums. Filing documents no longer required a trip to the filing office, or in years gone by, a 25-cent filing fee for secondary pleadings. Lest you get the wrong impression, I do not yearn for the good old days. Rather, I embrace the changes that have been accomplished by the profession. There is one area that I suggest we consider to improve the delivery of judicial services to our citizens: eliminate redundancy. With the advent of electronic filing and record documents being readily available, there is no need to continue to attach items that are filed of record as exhibits to filings and pleadings. In recently speaking with a well-known appellate advocate, I was advised that in reviewing the reproduced record and eliminating the duplication of items being filed would reduce the reproduced record by about 50%. Over 25 years ago, Judge Beck, Judge Fort Elliott, and I were privileged to participate in the Superior Court Centennial. That was a celebration of 100 years of service to the citizens of Pennsylvania. Since then, the court has continued to provide valuable and thoughtful service to the Commonwealth. I thank the PBA for recognizing the court's service and commitment to the Commonwealth, and to the judges and staff who serve. Thank you.
When we were looking at retired judges to speak today, we all came up with Judge Richard Klein, who has really spent, and he'll tell you why, a lifetime in the judiciary from the moment he was born. So Judge Klein, would you please tell us?
Thanks, Your Honor. I spent 28 years as a trial judge, 8 years on the Superior Court, and now a dozen years mediating and arbitrating. This, by far, was the best job I ever had. And it was made such basically because lots of the people in this room, not just my colleagues who have all become good friends, but the staff that I have is represented by Raylene Romeo, who's still with the court with Judge Lazarus, the court staff in general, and even more, the members of the appellate bar. I mean, I've really enjoyed the work, Mike, on your committee with the members of the Appellate Advocacy Committee and the other people, many of whom are here today, including the founders, Chuck Craven and Bob Gracie. Most people, when they see a judge, refer to them as Judge or Your Honor. I started referring to a member of the judiciary as Dad. My father was a judge 6 years before I was born, and I think he's still number 2. He didn't set the record, but he served 56 years as a trial judge in the Orphans court. So I went into Dad's business, and I see, you know, I'm not the only one. Judge Dubois went into her mom's business. It reminds some, I guess a number of you here remember Justice McDermott, who was, shall we say, regal in his approach. And when I first went on the bench, there was a meeting of the judges, and Justice McDermott said, you know, I'm glad to see young Klein here. He said, it goes to prove what I've always said, that the judiciary should be considered an inherited estate. We're talking about a lot about Judge Beck, who, you know, terrific person, great judge. She was the head of the panel, the first panel that I had. And in that panel, there was a motion filed just before the hearing, because I think there was a page limit. Phil, I think it was 50 pages back in those days, and this was a 70-page brief, and there was a motion to strike. And I called Judge Beck, and I said, you know, looks like this is something that we should grant. And she said, no, let me take care of it. Okay. So we go into court, and this was one of the early cases, so there were a lot of people in the courtroom, and Judge Beck took this case and said, by the way, counsel, I note that you wrote 70 pages when the page limit is 50. That means we're not going to consider anything you wrote after page 50. I do remember that in the first panel that I was all set for great argument after the panel thing, and I'm in the back room and they go, case 1, affirmed dissent. Case 2, affirmed dissent, affirmed. Got 3. I had no idea what was going on. I was about two cases beyond that. One of the things that I remember is that a lot of the hard lifting is done after the case is filed. I do remember one case very vividly where Judge Bose and I were on the panel with Judge Brodsky, and Judge Brodsky and I agreed in the preliminary vote, and Judge Bose was in the dissent. And I was talking to her about something else later, and she said, I said, well, I guess you're going to have to write a dissent in that case. And she said, well, I don't know. After all, Judge Brodsky's chambers is right down the hall from me. And I thought about Judge Bose, and I thought about Judge Brodsky, and I turned, I think it was to Raylene Romeo, my clerk, and I said, Raylene, we got to get ready to write a dissent in that case. I had it right. Judge Brodsky was convinced and swung. The only thing is that Judge Bose saw my opinion and got convinced, so it wound up Judge Brodsky writing the dissent. I think today, as much as ever, we see the value of a society run by the rule of law. And I'm proud of myself and also of my colleagues, because to be a good judge, you have to be honest, open-minded, and come to a case with, without bias and be willing to listen. And that's what I think that the members of the bar and staff in this room and my former colleagues and colleagues in this room have done. And I think not only has the Superior Court deserved applause for longevity, but it also deserves applause for being a collegial and very, very good court. And it was a pleasure for me to be one of them, to be here today.
Thank you so much. Our next speaker will be our current commission judge, Carolyn Nichols, who will honor the first minority members of the Superior Court. Thank you.
Thank you so much, Judge King and PJ Piniella, for giving me the assignment of discussing 3 amazing judges in under 5 minutes. So we got to hit it and quit it. We have more detailed biographical materials with you, but let's start with Judge Theodore Spalding. Judge Theodore Spalding was the first African-American judge to serve on the Superior Court, and he was known for his keen intellectual ability, and he brought a practical application to the law with boundless energy for public service. Now, his pragmatism was birthed in the harsh reality of the segregated Jim Crow South. He was born in 1902 in Concord, North Carolina, the son of a carpenter, who with his wife amazingly put all 7 of their children, including Judge Spalding, through college, through segregation, through the explicit racism of the time of 1902. After graduating from college and law school in Detroit, he moved to Philadelphia in the 30s. In the 30s, then lawyer Spalding was very active in helping people in the Depression who were unemployed, suffering extreme poverty and deprivation, helping unemployed homeowners fight to keep their homes with the huge foreclosure rate that was going on at that time. Moving to the 40s very quickly, he became president of the Philadelphia chapter of the NAACP, and he fought racial injustice and fought the inequitable conditions going on. He worked with NAACP attorneys across the country. At that time, racially restrictive deed covenants were legal, and it blocked African-American homeowners from being able to buy homes. Attorney Spalding at that time was very active in litigation and political strategies to challenge that inequitable practice. In 1940, he started his own law practice, and at that time, only the Friends Society in Philadelphia would rent him space. No other building in the entire city would rent space to his law firm at that time. In 1953, Governor Fine appointed Spalding, now Judge Spalding, to Philadelphia County Court. He was able to serve 2 years, win a full term, and then later he successfully won a second term. Also during that time, I don't know how he pulled this off, but in 1957 he was actually appointed by the UN to a subcommittee for the protection of minorities. I'm not sure how that happened, but that's pretty amazing for a judge. Now that committee still exists as the advisory committee. He also, being forward-thinking, recommended the creation of Philadelphia Community College, which was established in 1965, all while doing a busy trial court schedule. Now, how did he get to our court? In 1966, Governor Scranton appointed Judge Spalding, the very first African-American to serve on the Superior Court, and he was recommended by this bar association, by Pennsylvania Bar Association, yay, so you're on the right side of history, as well as the Philadelphia Bar Association. And he was elected, he was appointed and won a full term. Unfortunately, Judge Spalding only served 8 years on our court because of illness. He left in 1973, and he passed on in 1974. And his son followed him and became a lawyer himself until he passed on in 2003. My second profile in excellence, I'll call it, is Judge Justin Morris Johnson, who was the second African-American Superior Court judge. And he, above all of the judges I've researched, he set the standard for community and faith-based service and judicial excellence. Just an amazing person. Born in Wilkinsburg, Pennsylvania in 1933. He transitioned and left us in 2021 at age 88. Governor Richard Thornburgh appointed Judge Johnson to the Superior Court in 1980. You heard about the expansion of the court which took place, and Judge Johnson was part of that expansion from 7 judges to 15 judges. He served on this court until his retirement in 2007, also taught at Duquesne University Law School. He was known and recognized by his peers as brilliant, logical mind, persuasive ability, as a legal advocate and jurist, as well as his dry sense of humor. He also served in the military. After graduating from the University of Chicago in the 50s, he served active duty and reserve duty, and actually was a aircraft commander and flew flights in active duty flights into Vietnam. Once he graduated from law school, he joined the amazing firm, incomparable firm of Johnson, Johnson & Johnson. And it's not that other Johnson, Johnson, Johnson. This firm is so amazing. His father, Oliver Johnson, graduated from Harvard University, like at the turn of the 20th century, and he was the first black assistant district attorney in Allegheny County. And Judge Justin, I get the Johnson straight, Judge Justin Johnson's brother, Livingston Morris Johnson, also just an esteemed lawyer, became an outstanding judge on the Allegheny Court of Common Pleas. So this is really a power firm when you talk about Johnson, Johnson & Johnson. In 1969, the Pennsylvania Supreme Court appointed Judge Justin Johnson, keep them straight, to the Pennsylvania Board of Law Examiners, and he remained on that board for 20 years and served as chairman for 6 years. In 1970, he was the first African-American to serve as a solicitor for the Pittsburgh Board of Education, and he served on law firms. He was a tireless advocate for justice. He was always in the forefront, very outspoken for civil rights and justice in Western Pennsylvania. He and his wife were very active in the Presbyterian Church, so faith-based community service and fighting for social justice was very, very important for him because he was mentoring youth and so many awards that it would take just a whole program just to go through it all. Last but not least, we have Judge Cheryl Lynn Allen, who is the first African-American woman, also out of Pittsburgh, that was elected to our court, born in 1947. She exemplifies resolute faith to succeed and persevere against all odds. It's very, very difficult for a woman, an African-American woman, to become elected to the court. You see how much time from 1895 until 2007 before an African-American woman was elected to this court. She was elected in 2007 and retired from this bench in 2015. Prior to that, she served on Allegheny County Court for, I believe, 2 terms on that court until 2001. Again, Judge Allen was very active in the community. She was a staff attorney for the Pennsylvania Human Relations Commission as well as Neighborhood Legal Services. During her tenure on Allegheny County Common Pleas Court, the Pennsylvania Supreme Court appointed her to the Juvenile Court Judges Commission. She's the daughter of a steelworker, and she often stated that she never saw herself as a lawyer. She didn't know any lawyers, nor was she encouraged to go into law by any school counselors. So she taught school. Her first career was as a second grade school teacher in the Pittsburgh school system. But what drove her into law was actually the assassination of Dr. Martin Luther King in 1968. And that sparked her interest to look into law. She wasn't sure she could do it, but she was able to get into the University of Pittsburgh Law School and graduated in 1975. And she has said that she was working on her law lessons in tears, wondering, did I make a mistake leaving my school career to come do this? I don't know if I can do this or not. But she kept persevering, making that transition from an education career to a legal career. She's received many awards and honors, and is very active in ministry. She works with many faith-based and nonprofit organizations, and a founding member of Women's Christian Ministry, and is on many boards, more boards than we have time to discuss. So, as we look at these 3 judges, we can all be inspired regardless of our backgrounds, because these judges truly broke through societal norms and limitations about race, about gender, with excellence in their humanity, as well as jurists, and grounded in the practical reality with boundless energy for public service, supported by their resolute faith to conduct themselves as standard bearers for integrity, always keeping their eyes on the prize, and always seeking justice, always seeking justice. Thank you.
That was well spoken, Judge Nichols. Thank you very much. We are going to give you a break after the next speaker, and then we'll take a break, like I just said, and we'll start part two. You know, this is not bad for judges. We're only running about 15 minutes over schedule. It reminds me of the first en banc that I presided over during the pandemic. We had to do it remotely, and I didn't put any time limitations on the judges for questions. And in the first case, we did it by way of seniority. I went through all the judges, and about 3 hours later, I called the second case for argument. So this is really not bad today. It is my pleasure to call, there's so many different titles: President Judge Emeritus, Justice, Judge, Representative, District Attorney. He has served in all three branches of government, but Senior Judge Coriel Stevens. And by the way, despite all those titles, he really likes Grandpa best as his title. He's going to talk about what it was like to be on the Superior Court, go up to the Supreme Court and reverse us at times, and then come back to the Superior Court. Judge Stevens.
Thank you, President Judge Piniella. As the last speaker before you break, I know my time limits. Thank you for coming, and I want to thank Pennsylvania Cable Network for their continued commitment to public service. I absolutely love the Superior Court. We're not just colleagues, we're friends. We're really friends. We know each other's families, and it's just great. And the staff, as you know, they're courteous, they're competent, they're great to work with. So I'm here because a long time ago, and I know some of these judges since we were trial judges back in 1991, I happened to be at a non-political summer outing, and my former law school classmate was there, Tom Ridge, who was governor, and Lieutenant Governor Schweiker. And they asked me about running for Superior Court. And of course, I said sure, because I never thought it would happen. But then I got a call from Matt Ryan, who was the Speaker of the House, Judge McCune, who was on the Superior Court, and I was successful. And with all due respect to Kate Ford Elliott and to Phyllis Beck, who were on the court, and two of the most accomplished women in Pennsylvania history, I had no idea what the Superior Court was, what they did. I couldn't name any of them. When I was at caucus meetings in the legislature and we discussed the legal effect of bills, we would always say, let's just pass it and let the judges deal with it. Yeah. So my perspective on that has changed dramatically. So 13 years I'm on the court, and halfway through my term as president judge, and I'm approached by some bipartisan leaders in the legislature about filling a vacancy on the Pennsylvania Supreme Court. Now, how do you say no as a lawyer and as a judge to have that opportunity? It's hard, and I did not want to leave the Superior Court because I didn't know how was I going to be accepted as an appointed judge and give up. I had won 18 elections, 2 statewide. How do I give up my elected commission? But Chief Justice Ron Castile and then Tom Saylor treated me, and all the justices treated me as I was one of them, not just there for 2.5 years. And current Chief Justice Deborah Todd, who's been a longtime friend since we worked on the Superior Court together, had cases together, were on panels together, was my mentor. So finally, in conclusion, I want to say coming back, I had that same concern. Would these judges now consider me irrelevant? Because now I'm an appointed judge coming back. But no, they treat me just like they did before, with dignity, with respect. They want my opinion. And I do want to mention, because President Judge Piniella is here, when my nomination was going through the Senate, Judge Piniella was performing my wedding ceremony on June 30th, 2013. And it was a small, small gathering family. And my phone was vibrating in my pocket. Now, those of you who are married will understand this. As much as I wanted to reach into the pocket and see what was going on, I thought for my own health and prudence that I would wait till the ceremony was over. And it was Senator Lisa Baker that told me I just got confirmed unanimously. So that was, as Judge Piniella always says, that was better than a great day. So in conclusion, you know, I'm back on Superior Court. I have a full staff. Two of my wonderful clerks are here today. Former clerks are here. Judge Gracie, formerly on the court. And many of you lawyers have appeared before me. I just want to mention one comedic relief which we get sometimes. I had a pro se brief, 1 page, and basically the statement of the case was that he was abducted by pirates, so he couldn't really give me any more authority. But if I needed authority, I should watch the old show Miami Vice. That was the brief. And don't be surprised, he lost, okay? So thank you for being here. Thank you for paying attention. And again, I love my colleagues. I love my opportunity to continue to serve you all. And thank you for the work you do.
Well, we're going to give all of you a chance to stand up and stretch your legs a little bit while we change our panels. We'll be back for part 2. Thank you.
Dick, good to see you.
you very much. Welcome to part 2 of our program, in which you will be hearing from our commission judges. But first, we will provide an overview of the operation and organization of the courts, and then you will be hearing jurisdiction and the trending topics. All right. So, many practitioners have asked about the operation and organization of the courts. The Superior Court could not handle the heavy volume without the work of our leaders and staff in our departments. We felt it was important to highlight our department leaders and describe their responsibilities because they're integral into the management and organization of the number of cases that we address annually. To start with, our executive administrator of the Superior Court is Jennifer Traxler, and she carries out the assignments necessary to the efficient operation of the court, which includes overseeing and analyzing administrative procedures and operations, monitoring expenditures, overseeing all personnel issues, executions of contracts, and she ensures the court compliance with various regulations, as well as carrying out and communicating the directives of the president judge. Our prothonotary, Ben Kohler, serves as a conduit for all the filings in the court and is charged with the clerical duties and responsibilities of the court. These responsibilities include docketing all appeals, miscellaneous petitions, ancillary filings, certified records, applications for relief, orders, briefs, and dispositional decisions. The prothonotary acts as a liaison between the trial courts, the parties, and the court for various communications related to the Superior Court appeals. They are also responsible for monitoring and maintaining all certified records. They circulate and distribute the filings that require court action to either central legal staff or chambers, and they submit dispositional decisions to the reporter's office to prepare for publication. Essentially, the prothonotary is the public face of the court, and the prothonotary staff has approximately 50 filing clerks and court criers and mailroom employees. Our central legal staff is headed by our chief staff attorneys, Phil Yoon and Catherine Shelley. Central legal staff consists of 25 attorneys, 6 secretaries, and assists the court in screening appeals prior to listing on the panels by checking for defects in notice of appeal or court dockets, both appellate and trial. They ensure all appellate attorney representation issues are straightened out for purposes of appeal. They prepare motions, make recommendations, draft orders for review, circulate research memoranda to judges on various topics, review proposed decisions by panel judges for conflicts, prepare applications for re-argument for review by the full court, and they update the court on developing case law. Dolores Bianco is the reporter, and she is responsible for maintaining accurate journals and recording votes on opinions, memoranda, and petitions for re-argument for each case before the court. She prepares the statistical reports, compiles the assignment lists, and records of the cases, assignment of judges, maintains a record of all panels, compiles the paper books, which are kept until the cases have been reported to the printer, and updates chambers on case statuses and inventory. Our legal systems coordinator is Peter Johnson. He helps maintain the court's computer and network systems and serves as the court liaison with AOPC for the maintenance of the court's case management system and oversees the court's communications, while also ensuring that the security of the court's technology environment. During the pandemic, they did an effective job, which was a huge responsibility to ensure that the judges, chambers, legal staff, and all the departments could continue to work remotely. Their department consists of staff of 7 technology specialists. We also have our court criers that are in Philadelphia, Harrisburg, and Pittsburgh, and they provide for the courtroom operations, including opening and adjourning, the distributions of the case briefs and records, preparing the journals of the court and prothonotary, and they assist coordinate the security in the courtroom, and enforce the courtroom decorum. To all of our department leaders, thank you for ensuring the efficient running of our court. We really depend on you as we are one of the busiest courts in the nation. It is now my pleasure to introduce Judge Ann Lazarus, who will discuss the operation of the court.
Thank you. It's my pleasure to talk to you a little bit about the court's appellate case flow. And as you know, the Superior Court is a court of general jurisdiction, and we hear cases that involve almost every aspect of the law with the exception of capital homicide cases and cases that are involved with statutory regulations dealing with other counties and the like. So when a notice of appeal is received by the prothonotary from the trial court, that includes notices of appeal from the trial court, permissions to appeal, permissions for petitions to review, and other miscellaneous petitions, all of which are reviewed by our wonderful central legal staff. And they look at jurisdictional issues, and cases sometimes issue a rule to show cause as to whether or not there is appropriate jurisdiction in our court. They also deal with applications for relief, and they also look at those for jurisdictional issues. Original records are due in the Superior Court within 60 days, 30 days for children's fast-track cases, so you can imagine how much time is spent getting those records from the trial courts. They never come at 60 days. They must include the trial court opinion, and the trial court, pursuant to Rule 1925B, as you know, the trial court must give a clear directive for appellants to file a concise statement of matters complained on appeal. Briefing schedules issue once the court receives the complete record. An appellant generally has 40 days, 30 days for his children's fast track, to file an initial brief. The appellee's brief will be due 30 days after the filing of the appellant's brief. The appellant may but is not required to file a reply brief. And there are consequences if there's a failure to file briefs, as I'm sure some of you know. If the appellant fails to file a brief, it results in the dismissal of the appeal. If a brief is untimely but accepted, it results in an automatic submission rather than argument. If an appellee fails to file a brief, it is precluded from oral argument. The brief that is untimely results in preclusion from oral argument and may result in the panel striking the brief and not considering it. Once an appellant files a brief, if a non-incarcerated and non-PCRA, the prothonotary will send a reply letter, and the appellant can choose standard 15-minute argument, an expedited 5-minute argument, or the case may be submitted on briefs. If an appellant is incarcerated, the appeal will automatically be submitted on briefs. When we deal with the assignment of cases are assigned, we try to figure out the following year's calendar. So we're thinking about the calendar now for 2024. The prothonotary will designate an appeal as ready to list based on their briefing status. And once ready, the appeal will be listed on the next available submit or argument panel. We hear cases in panels of 45 cases, whether they're submitted panels now or argued cases. Each judge on the panel will be assigned as the initial majority for 15 cases, generally assigned in batch. We try to make this as equitable as possible, and we assign judges predominantly on a wheel. In most cases, the first 15 cases will be assigned to the judge with the most seniority, the next 15 to the next most senior, and the last with the least, judge with the least seniority. The president judge is always considered senior. Senior judges are always considered least senior, unfortunately. For argument cases, expedited cases will be listed first, and then regular cases will be argued. But I will say, as a practice tip for everyone who's here, we spend a lot of time on argued cases. And the nature of argued cases means that that's what we do, because not only are we responsible for preparing those cases, and as I'm sure most of you know, we are considered a pretty hot court. But we also talk about the cases during lunch when the cases are being argued and after, because we have to vote on who's going to be assigned the majority and who's going to be assigned the minority in those cases. So if you can afford it, if your clients can afford it, we always just spend that much more attention, because the way our submitted cases are looked at is when one of my esteemed colleagues sends me a draft of an opinion or a case for submission on a submitted case. and it looks good to me, I probably just sign off on it. But we just we argue a lot about argued cases. Some of you may have realized that sometimes we don't get to your opinions within a very short period of time. And that's because one judge will write a draft of an opinion, circulate it to the other two judges, and if we don't get another judge to join us, sometimes another judge will write a dissent. The cases go back and forth. We argue about verbiage, we argue about the law, we argue about almost everything you can argue about, and ultimately the sausage gets made. And once a judge has an agreement with another judge, that's considered the majority, and somebody can file a short dissent or a concurring statement. Voting on cases lasts approximately 3 weeks. Judges can vote to join, concur in the result, note a dissent, hold, write a concurring opinion, a dissenting opinion on a memorandum, or a concurring statement or a concurring opinion, dissenting statement on an opinion. Central staff reviews all of our cases for conflicts. Once they say that there are no conflicts with either existing law or a currently circulating decision, the case is cleared. If all the votes are in for the circulations, then they get filed. We are often asked for reconsideration. The reconsideration rate has gone up significantly in the last year that I can tell. And the panel first gets to decide whether or not it would like to reconsider its own argument. If the panel decides it does not, then a vote goes out to the entire court, and they decide whether or not they want re-argument on the case as opposed to reconsideration. If there are a majority of commission judges who think that the case should be re-argued, then it is listed for re-argument. If there is a tie right now, we only have 14 commission judges, and if there is a tie, we go for re-argument as opposed to not doing re-argument. When we re-argue a case, the underlying decision is of no moment. It is voided. Now, the case that is listened on when we decide the re-argument, we can reissue the original decision, but it would be reissued by a majority of 9 out of the 9. It may be totally precedential. Most cases on re-argument are precedential, and most cases on re-argument result in opinions rather than memorandas. We also hear cases, and that's how we hear cases en banc. We also try to incorporate those judges whose opinions have been appealed in our en banc to the extent that we can. We try to vary the number of judges who are on the appeals for en banc. We generally have somewhere between 3 and 4 en banc sessions per year. We try to make sure that there's a rotation of the judges on our court that are participating in the appeals so that we have a broad range of decisions and opinions about those appeals. En banc panels are listed approximately 2 months prior to oral argument. An en banc case may be listed on a panel even if the briefing isn't completed so that we know that we have the en banc sessions. We generally hear somewhere between 4 and 8 cases in an en banc. In fact, we'll be doing another en banc session this year. I believe it's December 7th. We will deliberate and advise on preliminary votes in the en banc. Based on those votes, the presiding judge will assign majority and minority writings. And then we will circulate those the same way as we distribute and circulate all other opinions. Central legal staff does not review en banc decisions for clearance. A great majority of en banc decisions are precedential opinions, and applications for re-argument are not permitted from en banc decisions. We also hear special disposition cases. A very limited number of cases will be assigned to a specially designated panel due to unique features. For example, a high-profile case, and the president judge is assigned to make sure that those judges who want to recuse from that are not put on those type of en banc panels. One example of that has been the Mumia Abdul-Jamal cases. Another example probably was the Bill Cosby case. And we wanted to make sure that those judges who were responsible for those cases underlying did not have to appear on the en banc on those cases. Cases of public interest are listed in the court's website, and you can find them. And that website is PA Courts US. But I just want to give you some statistics. In 2019, right before the pandemic, we had almost 7,600 cases that were filed. In 2022, the last statistics that we have, we were back up to 6,466 cases. So we're almost back to pre-pandemic levels. Chambers decisions filed. In 2022, 168 decisions per judge have been filed each year. That's an awful lot of work. In 2018, before the pandemic, it was up to almost 240 cases per judge. So you can imagine how hard this court is working. We have, in the applications for, the highest number of applications for reconsideration that were filed was in 2020, 14% were granted. In 2022, the most recent statistics, we only granted 5.3%. So I guess we're getting better. So that is how the court operations flow. And I want to turn this over to my colleague, Mary Murray. No? I'm sorry.
Oh, that's all right. We're on a specific
Okay.
rule here.
Never mind.
So now that you know a little bit more about the behind the scenes and the operation and organization of the Superior Court, we're now going to turn to specific areas of law. And you're going to hear from the commission judges. There's one judge you will not be hearing from, and it is Judge McCaffrey, who was able to fit us in his schedule. He's a little busy these days. And we're thrilled that you're here to join us.
I figured I haven't shut up for 10 months. Today's my opportunity to stay quiet.
Thank you. The first person we're going to hear from is Judge Victor Stabile, who will be addressing the civil component.
All right. Thank you, Judge King. Thank you, everybody, for being here today. It's a distinct pleasure and an honor to be able to address the bar. And also, I want to thank our President, Judge Piniella, and Judge King for the program today, as well as the Bar Association. It's a program that I think is unique amongst many. So let me dive right into it, because I have to start my stopwatch over here since we're on some sort of a time schedule. So here we go. My job is to talk to you about the court's civil cases. You know, the Superior Court, when people think of us, really think of us as a court that deals principally with criminal cases and family cases. And in fact, you know, that's a large part of our docket. Pre-COVID, we were a high of about 8,000 appeals a year. When I went back and looked at statistics, which I think generally hold true, of those, about 60% were maybe criminal, and the rest, 40%, were civil, which included family. And within that civil side, which includes family, about 40% were family, but 60% of that last 40% were civil cases. My point being that the civil cases are a very important part of our jurisdiction. They have been a part of our jurisdiction since this court was formed in 1895. We have retained general statewide jurisdiction, except for those carve-outs that went to the Commonwealth Court in 1970. While the background of many of our judges, based upon the sheer volume of criminal and family law cases, has developed substantial expertise in this court, and many of our judges consider themselves experts in those areas, the civil cases are somewhat unique because they cover so many different areas of law. And as commission judges on the court, we're expected actually to be somewhat of jacks of all trades. We are expected to study and master enough law in each of these areas of law that we have at least a good working knowledge of all of these civil areas so that we can understand your arguments, intelligently address the law, and refine the law in each one of these cases in order to enhance and create the jurisprudence in our Commonwealth. Given our broad jurisdiction, then, it's not unusual or unexpected that we are continually establishing new and controlling precedents that expand upon law, and those are frequently issued. So just to give you a sense of the civil side of the court and the trends and the types of issues where we're pushing the envelope, I'd like to kind of highlight a number of different areas for you to give you a sense of where the court stands and the importance of the civil side of the work that we do. So, of course, there's always the area of jurisdiction. It's a perennial issue and pops its head up in just about every type of case that we have. Probably the most notable case, and what I'm going to talk to you about, are cases really just from the past 2 years. That small snapshot showing you the trends and the highlights of where we go and the importance of our civil cases. In jurisdiction, probably the most visible one was the recent case of Mallory versus Norfolk Southern. That case actually was heard in the Superior Court panel and en banc, made its way to the state Supreme Court, and was heard by the United States Supreme Court. So what made that case so worthy of not only state Supreme, but United States Supreme Court review? Well, Pennsylvania has a law requiring out-of-state companies that register to do business to agree to appear in Pennsylvania on any cause of action against them. And the question was whether that, quote, voluntary consent comported with due process. Well, many people thought that coercion really violated due process. Surprisingly, the United States Supreme Court said no, it did not, but left open the door for future challenges to look at that issue again under the Dormant Commerce Clause. Last time I looked, very recently, that issue is in fact making its way through the courts. I expect that perhaps the highs in Washington will probably be revisiting that case. An extremely important case, a civil case out of Pennsylvania that other states are also looking at because not many other states share that consent type statute. So moving ahead on jurisdiction, we decided a case en banc, by a panel called Hammonds versus Ethicon. This is out of the Philadelphia, multi-tort cases. And the Supreme Court affirmed the jurisdictional issue that we held in that case. We extended or applied the Bristol versus Myers case. And what was that about? Well, the court held that the defendant in that case could be subject to personal jurisdiction over a product's liability suit, even though none of their conduct relevant to the elements of the cause of action occurred within the forum state. All that was necessary was that specific jurisdiction be shown and that the allegations against the company be tied to the cause of action. So the Supreme Court clarified and affirmed what we said, that you are subject to jurisdiction, personal jurisdiction in Pennsylvania, whereas there is an attachment to the cause of action. That's what establishes that jurisdiction. Of course, we continually have to face collateral orders under Rule 313. There's always a press at the trial level when you lose an important issue that may be dispositive in your case to try and get an immediate appeal. We are constantly looking at Rule 313, the collateral order rule, and I will tell you that on that issue, probably the clearest case where we do grant collateral order in areas where privilege has been decided and disclosure is threatened at the trial level. I will also tell you that Pennsylvania differs from federal courts on this. The federal courts and our state courts do not see eye to eye on collateral orders, especially in the privilege area. Another one that really trapped us, and I know really caused a lot of dissension and angst in the Superior Court, was what we now famously refer to as the Walker Rule. I'm looking to see how many pained faces are in the audience. Okay, so what was this about? In 2018, the Commonwealth filed a single appeal over multiple dockets, and the Supreme Court looked at it and said, you know what, we're not doing that anymore. Rule 341 says that when you have an order deciding multiple dockets, you need to file separate notices of appeal to each docket. Well, we watched many litigants fail on that over the course of a couple of years. I think at one point we were up to 80 cases that were dismissed on that technicality. In response to what we finally wrote in dissension on that issue, the Supreme Court did grant relief on a case called Commonwealth versus Young, where they said we still are going to abide by this Walker Rule under 341, but we will allow the appellate courts to look at the safe harbor provision of Rule 902, which basically says if you timely file your appeal and you louse up the number of appeals you should be filing, the appellate court can send you back to correct that so that your case can be decided on the merits. You don't lose jurisdiction. Moving ahead, there's always the tricky issue of venue. Just when you think things are decided, well, there's been a recent rule change, as I'm sure most of you know, on medical malpractice cases. Effective January of 23, medical malpractice suits for purposes of venue are going to be treated just like many other cases where the defendant can be served or the transaction or occurrence that gave rise to the suit took place. Prior to that, you could only bring the case in a county where the case or treatment occurred. A sea change in what was a remedial rule. I expect that while now med-mal cases will be treated the same as other cases, you're still going to be seeing challenges to proper venue as well as forum non-convenes. The rule change will not change those challenges under our civil rules. On jurisdiction, there's also in the area, excuse me, of venue, the case of Hangley versus Husqvarna, decided by us in 2021 en banc. Aliquotter has been granted by the Supreme Court, and what's that about? Well, the question was whether the trial court abused discretion in finding that the contacts of Husqvarna with Philadelphia didn't satisfy the quantity prong of that venue analysis. You have to look at both quantity and quality. Well, you know, statistics can be made to look like a whole lot of things, and in that case, I think their business in Philadelphia was something like 0.0018%, but in comparison to the size of the company, that was not a small number of cases. Supreme Court has granted Aliquotter, is going to finally give some guidance on that issue. And then finally, for some reason, cases kind of come and go in a rash form. A case by the name of Failer versus FedEx, a case 2021 decided by us, was a motion to dismiss a case based upon form non-convenes under the Uniform Interstate and International Procedures Act, or what people will refer to as simply Section 5322E. We looked at that and said, no, the court was wrong in dismissing that. The issue was whether it was Pennsylvania or, I believe, Maryland. But we did send it back because a similar rule that looks at intrastate transfers, Civil Procedure Rule 1006D1, needed still to be considered. So the case clarifies using challenges to venue both on a forum non-convenience ground, both within the state and between states. So it's an important case for clarification to the bar if you're going to follow that. In the civil rule areas, it's just simply not enough to read rules anymore. You need to look at case law to see how they're interpreted. Well, there was a recent case, HTR Restaurants versus Erie Insurance, where the plaintiff's attorneys, in a very creative manner, attempted to use Rule 213.1, which is a coordination rule of cases between counties, to treat it almost like a class action and convince the trial court that the other actions with Erie Insurance on the same issue pending in other counties should be coordinated up in Allegheny. And not only that, but all other present and future actions against them on the same coverage issue should be subject to that rule as well. Well, we reversed on that broad reading of Rule 213.1. The Supreme Court has granted Aliquotter on that case and is going to actually only look at the issue as to whether or not a non-party can make use of Rule 213.1. And I see Scott Cooper in the audience, so I'm sure will promptly let us know how the Supreme Court decides that case. Thank you, Scott. All right, and of course, then there are also the perennial financial motor vehicle responsibility law cases. Are stacking cases, will they ever end? I think the safe answer is no. We all know that in Gallagher versus Geico, the Supreme Court said that the household vehicle exclusion contained in that law violated the provisions of stacking. It was an impermissible de facto waiver that was attempted to be read broadly in a case called Erie versus Mione, affirmed by the Supreme Court, affirmed the Superior Court, and said, wait a minute, we're not going that far, where the household exclusion does not invalidate all cases, but is only unenforceable where it's a de facto waiver of stat coverage, where there is no valid rejection form. So the Supreme Court has pulled back on that. I'm sure we've not heard the last of stacking. There are, every time they decide one issue, it seems there are 6 others that get generated from that. In the torts area, we've got some very interesting cases. Again, these are all very recent. Punitive damages. Supreme Court just affirmed the Superior Court on a case called Burt versus Turk. The issue in that case is how you calculate the ratio of punitive damages when you have multiple defendants in a case so that the damages are not unconstitutionally excessive. We said, and the Supreme Court affirmed, that you can do that on a per-defendant basis without violating the constitutionality of punitive damages. In following that issue, I see that people are already crafting arguments challenging the presumptive constitutional ratio on that. Okay. Moving ahead, we had the chance on tort immunity to address a federalist statute on the gun control law. That'll be an interesting one. The Fair Share Act, this one may have slipped past people, but in dicta, we held in Spencer versus Johnson that that act only doesn't apply unless the plaintiff is comparatively negligent. In the insurance area, we have our COVID cases in front of the Supreme Court, where you either think that we've issued conflicting or consistent cases. They're going to take a look at whether Pennsylvania should remain an outlier or joined by the rest of the states. Arbitration, Saluti versus Huber, en banc, allocator has been filed. That's an extremely important case when you go onto a website and click the terms, and inside the terms it says you've agreed to arbitration. The question is whether that's valid, has the potential to affect commerce in a very substantial way. Oil and gas leases, a very niche area, really its own area of property law. We continually get asked to decide those, and one of the last cases we looked at reversionary interest. If you're interested in looking at that archaic law, I'll refer you to Douglas Equipment versus EQD Production from 2023. So hopefully, I've tried to impress upon you that the civil area that we decide is important. It is an important part of our caseload. It has significant numbers, and for the court, we're constantly being challenged to decide new issues or to extend law, and it's an area where if you practice in civil law, that you also have to follow our precedents very closely. I thank you, and I apologize for the 3 minutes I went over time.
Thank you very much. Our next speaker is Judge Alice Beck-Dubois, who will be addressing some of the issues in criminal court. Thank you.
All right. Well, thank you. I think I now have 7 minutes to talk. But let me just make one more comment about the Superior Court. We affirm about 80% of the time. I think that's an important statistic, especially when you're advising your clients. And also want to thank the Pennsylvania Bar Association for sponsoring this. As you can tell from Judge Sabile and from me and the rest of our colleagues, we love talking about the law, and we would be very happy to come back, and I'm sure we could spend hours talking about recent developments in civil law. I could spend hours talking about recent developments in criminal law, but I only have 7 minutes. So I'm going to talk about one or two criminal cases. But I think the real reason that I'm going to talk about these cases is both these cases, there is a diversion of views on the court about how we should go. And I think it's sort of helpful to show people and neither side is right or wrong until the Supreme Court decides. But it sort of just shows how when judges on this court are faced with a similar law and similar fact pattern, and there's no law definitive in an area, that we can come up with intellectually honest answers and analysis on both sides. So I'm going to start by talking about a recent en banc case, Commonwealth versus Moraz, which also part of that too, the history of that case also involved another case, Commonwealth versus Chicklin. So let me just give you a little background. I'm going to assume that most people in this room don't practice in the criminal side, so I will sort of start at a very basic level. But the ultimate point of this is so that you can see how we disagree, but we're not disagreeable. So what this series of cases really deal with is sentencing under DUI. And so for those of you who don't practice in the criminal area, DUI is charges in which the defendant is charged with either driving under the influence of either drug or alcohol. And the legislature has set out a whole scheme for the elements of a defendant being guilty of a DUI and also the sentencing. And in terms of the sentencing for the DUI, it is relevant to the trial court who does the sentencing if the defendant has any prior DUI convictions. And what the legislature has done is they've put a recidivism provision in the sentencing portion of that statute. And the legislature has said, if you have been found guilty of an earlier DUI, so you have a first offense of a DUI, and then you're convicted of a second DUI, the trial court has to impose a mandatory minimum sentence, and it also sort of it increases over time. So this issue first came up in Commonwealth versus Chicklin, which was written by Judge McCaffrey, who feel free to interrupt if I'm not properly articulating this. I didn't think he was going to be here, so I kind of am a little bit more nervous. Anyway, so what happened in Chicklin is the defendant was arrested for DUI, had a first offense, and as in many counties, the district attorney offered him the opportunity to go into ARD. ARD is accelerated rehabilitative disposition. Most counties have it, and for first-time offenders, you go through the program. If you complete the program, you're not convicted of the crime for which you were charged. And so in all of these cases, you have a situation where a defendant is arrested for DUI, goes through ARD, completes ARD, there's no conviction, and then again is arrested for a second DUI. And he is convicted in the second DUI because you're not eligible anymore for ARD. And then the question becomes to the sentencing judge, is the sentencing judge required to impose the mandatory minimum? So in other words, is that ARD considered a conviction, or is that just there's no actual conviction? So what happened in the general scenario, factual scenario in these cases is defendant is arrested for their first DUI, ARD, but then convicted for a second one. And so so if you take a look at the statutory language that defines a first offense, the statutory language itself is pretty clear, and the statute itself says that when determining whether or not there's a first offense, the trial court should consider whether or not the defendant went through ARD. So that issue came up before a panel with Judge McCaffrey on it, and Judge McCaffrey said, yeah, you know what, you're right. That's what the statute says. However, that statute's not constitutional. That statute violates that defendant's due process rights. And without getting into it too deeply, Judge McCaffrey reasoned that a defendant who goes through ARD is different from a defendant who is convicted. If a defendant is convicted, he has all sorts of due process rights that protect him that lead to the conviction. For ARD, if a defendant goes through ARD, there's no due process protections, and therefore that statute that defines ARD as a first offense is unconstitutional because it violates the due process law. So without going through the procedure too much, Superior Court decided to hear that case en banc. So there were 9 members of the court, and they addressed this issue regarding the due process clause and whether or not requiring a defendant to define and going through ARD as a first offense violates his due process laws. So after much discussion on the court and a well-written opinion by Judge King found, and she had 4 other judges who joined her on that, it did not violate the due process clause. Judge King's analysis was that ARD is a voluntary process. Defendant's not required to go through ARD. If he wanted to have all of the protections that a conviction would give him, could go to trial and see if he got convicted. And also, a defendant, before he agrees to go into ARD, is informed that the ARD could be considered as a first offense if the defendant in the future is ever convicted of another DUI. So that she got the votes. It was, I believe, Judge McCaffrey did not, and so as of now, the law in this area is that ARD is considered a first offense, and if the defendant is convicted of another DUI, the defendant is subject to the mandatory minimum sentence because ARD is constitutional, and that provision of the statute is constitutional. So I imagine I've used up my 7 minutes, and so I will but just to give you a general sense, I mean, one of the most interesting parts about serving on Superior Court is we get to grapple with these issues, and often our decisions, when they're cases of first impression, the answer's not clear, and each judge decides which analysis they find to be most intellectually appealing, and that's the direction that they go in.
Thank you very much. Thank you. Our next speaker is Judge Mary Murray, who will be addressing orphans court cases and jurisdiction. Thank you.
Thanks. So when you think of orphans court, you're probably like, okay, is she going to talk about kids? Is she going to talk about adoption? Or is she going to talk about wills? And technically, it's all three. So I'll give you a little bit of our statistics for orphans court. And I find it kind of interesting if you think about it. In 2019, we had 155 total orphans court cases throughout the whole state. But in 2021, we had 408, which is a huge jump if you think about it, but it was right at the end of the pandemic. But you have to say, would all of those kind of cases gone through the whole system? But when I tell you about the different types of cases, you may see why some of those cases could have come up from the pandemic. And in 2022, we were at 241 through August. So I don't know what the final numbers were, but I have been seeing a variety of cases in orphans court over the last couple years. That in real estate, but Judge Stabile already talked about it. So one of the things we've seen lately on our trust cases. And in the trust cases, we get a whole different variety of different types of trusts. Sometimes there are parties. I know there was one that I had sat on a panel where they were trying to terminate the trust. It had been in existence for a number of years, and that is currently pending, I believe, on aliquotter. There is specific interpretations of who gets the power of appointments under a trust, or specific trust provisions. What does this trust provision actually apply? Does it apply, is it interpreted this way or a different, totally specific other way? We also have stuff about changes on trustees or the actions of the trustees that were appointed. Sometimes it's a bank and they're unhappy with the bank. Sometimes and a lot of times it's family members or siblings that are fighting over who should be the trustee, or there were 2 trustees or 3 trustees and now there should only be 1 because somebody else has died, and who should be appointed in that to replace that trustee. So we have a variety of cases about trusts in general. Another case that have come up recently that kind of surprised me, but there is a bunch of case law on it, and is guardianships. We talk about, is somebody incapacitated? We had one recently in a panel out of Harrisburg where the gentleman who had been declared incapacitated says he's not. And he has counsel, and his counsel has tried to sign contracts, sign wills, sign divorce proceedings, file divorce proceedings, all kinds of stuff on his behalf, but he's actually considered incapacitated under the law and has a guardian appointed, and he's unhappy with his guardian. So those types of cases will come up. Also, one of the things that have come up that there are case law, and the case is Rosenblum, talks about attorney appointments of the incapacitated person. So under Rosenblum, the person is entitled to an attorney of their choice. And so sometimes a trial court will, or an orphans court in this case, depending on how, which county it is and how they're broken up. Since I come from Allegheny, we have an orphans court division. But if you're in a smaller county, it could be any trial judge. And they have appointed somebody as a guardian attorney. And the attorney, will come in and represent that person. And I've had cases where that person who is being considered incapacitated, has gone out and got another attorney. And so there's bickering that comes up on appeal is who is the right attorney. The trial judge, is this person able to appoint his own attorney? Is he not able to appoint his attorney? Is this attorney doing it right? Were the procedures followed? So those are types of cases we also get. And then the big question is, what if the person did plan for having some kind of incapacitation in their life? And they appointed a power of attorney, and they filled out a power of attorney. They had a person appointed as their agent to act on their behalf, but maybe that person died, or they're not happy with that person, and other family members have come in and tried to get a guardianship. So those are some of the issues that we've been dealing with under guardianship. Now, wills are always interesting, and we've had some phenomenally very interesting cases, I have to say, under wills. We always get the undue influence cases. You know, the spouse died, and, you know, the neighbor moved in, and the neighbor's been helping out, or, you know, the cleaning lady's been helping, and now she's getting all the heirs' assets, and the heirs are on the original will or not. Or, you know, maybe they've gotten an extra bank account that's now they're a beneficiary of, or an IRA that the son or daughter thought they were going to get, or the farm. So we've gotten those types of undue influence cases. The other ones that are kind of been interesting are the lost wills. And you think about it, the rule has always been, hey, if you can't find the will, it's presumed that the person who signed the will destroyed it. But there have been some interesting cases we've had lately where trial courts have found that despite a fire and supposedly the will being in a safe, and the safe being locked and opened months after, where the person who is technically the person who is the heir under the old will, there's no will in that safe. And the trial court has said, hey, you know what, I see the digital copy's here, the digital copy's fully executed. The gentleman has made it clearly known that he wanted to disinherit the child, so we're going to go ahead and allow the copy. So we've gotten those types of cases on appeal. Occasionally you'll get an inheritance tax. You know, you think that inheritance tax law is pretty basic. I mean, it's 0% for spouses, it's 4.5% for kids, 6, which used to be 6, the 12 for the siblings, 15 for everybody else. But maybe it depends on how the will was written. Was it written that the whole estate was going to pay the inheritance tax, or was it written so that the person who is going to receive the actual benefit, whether it's an IRA, a bank account, stocks, or what real estate, that they're going to pay the taxes? So those cases come up on appeal. Different distributions, depending if they're intestate, not intestate, how they will be handled. Additionally, the executors. What happens with the executor? You know, is the executor performing their duties correctly? If they're not, if they've disposed of assets incorrectly, if there were surcharges at the Orphans Court when they come up on appeal, we'll have those types of cases. But if there is not a will and you're distributing it under the actual intestacy law, there will be fights over who can administer the estate, which is why I think some of those cases have come up pretty quickly. And an election against the will has been interesting. We've had a couple of those where there's been election against the wills, and whether the prenup that the wife signed trumps her right to elect against the will, or has she waived it? Is the asset a part of the prenup? If it wasn't listed, is it now going intestacy? The other interesting one, which we love, is when children who don't want to claim the body eventually claim that they're now the heir and they're the only sole surviving heir, and the decedent's sister shouldn't get it, but because they were held out as a child for a couple of years, that they should now inherit. So we've had requests for DNAs testing and other samples to be taken under the estate. And the one last case we had under wills that I thought was very interesting, having done it for a number of years, is there were attorneys in one of my last panels who went out of their way during COVID to make sure that the will was properly executed. And instead of doing it through an open window or sending it there and having witnesses actually witness it in the nursing home and notarize it in the nursing home, since they couldn't get it in, they did it electronically and Zoomed it, had it videotaped, everything done. Notary was there, signed it on the pad, just like you'd sign any credit card agreement. And there was an argument, and the Register of Wills denied that actual probate of that will, saying it wasn't a valid signature. So some new case law that hopefully the Supreme Court will address at some point on those types of issues. The other half of the Orphans Court is the termination of parental rights, which of course we get for parents, and there are very specific statutes and what needs to be followed if there's a bond, if there's not a bond, if the child has been neglected, how many months has the child been under the state's care. But most of the cases we have that have issues with this area is the appointment of an attorney for the child. Is the child can have a guardian ad litem and also have an attorney to represent their legal issues. Is there a conflict? Is that appointed right? There's been a lot of litigation since I've been on the court over those issues. And since my time is almost up, the last issue segues into my, to the next speaker, is adoption. And the statutory, see if the statutory requirements are actually met. Was there counsel appointed for the child? Sometimes we think there should be, depending on who adopts, and who is standing to actually adopt in their relationship. We've had some unusual cases with step-parents that have no blood ties to the child that want to adopt or to prevent an adoption. So those are the types of cases we've been seeing on appeal.
Thank you very much. Our next speaker is Judge Maria McLaughlin and she will be addressing issues in family law.
Good afternoon. I've always considered family law cases to be some of the more difficult cases that we deal with on the Superior Court. They're complex, they're fact-specific, they're filled with emotion, and then we're an error-correcting court. So we are not the trier of fact. So these things are not for us to deal with. We're to deal with whether or not there was an error that we need to correct. I'm always mindful that our decisions affect families, affect people's lives. This is with every area of the law that we deal with, not just family law, but is it oh so evident with family law cases? All you have to do is read the facts, and it's very difficult to detach yourself and look for the errors, or not. But having been a trial judge in family court, I'm always mindful of the balance that we need to take our time to delve into the case, to read the transcript, to look at the balancing act that we need to look at, which is these families need our decision and in order to move forward. With the dockets being so busy as they are at the trial level, just a simple request for a continuance can bring disruption and confusion into a child's life. And that's not missed on our court. For example, if a case is continued to the next available list in some jurisdictions, maybe months later, and let's say it's an issue of summer camp, and the next date, summer has passed, so that issue is moot. It may seem insignificant when you look at it in the larger scale, but it's very significant and very important to that child and that child's family. So it's really a tough thing that we have to deal with, and I just like everybody that deals with family law to know that it's not lost. Those things are not lost. Certainly not on me, because I was on the trial bench, and so I know what it's like to be on that other side, also as a litigant. So when you go through a custody case or a divorce case, I think having gone through it, it makes you more cognizant of what it's like not to just be the judge ruling on that case, but also being on the other side of the bench. And so, and I think, and I hope you can read that when it goes into our decisions, that these things really are not missed on us. I also think that it's beneficial for me to go over some of the cases, maybe just a few, that show how the law is evolving in family law. You know, families look different today. There's different ways of having children today, things that, you know, we never thought of. And so our law is evolving just as all of these things are changing. I remember being a custody judge in Philadelphia when the Superior came out with the factors, the custody factors. And boy, the judges were all over the fence with, oh my God, we can't even handle our docket, let alone now with every case you're expecting us to go through all of these custody factors. And Me, I'm always like the gal with the glass half full. I looked at it like, well, look, to me, I think it's making it easier for us and more organized, because you want these cases that are so fact-specific to have some kind of uniformity all over the state of Pennsylvania. And what I've realized with traveling the state and dealing with cases from all over the state, when you get a family law case, I mean, you could shut your eyes and not look at what county it comes from, and it sounds the same. There's always the same issues. They're different facts, and some may be rural and some may be city issues, but the family dynamic is the same. And so I thought that the custody factors were actually made it easier for us. And when I was a trial judge, I would just keep these custody factors on my bench and go over them very quickly, and let the lawyers, go over them and say, like, look, this is what we need to rule on. And so to me, it made it easier. But we have now cases. We have a case that's coming out soon. We haven't ruled on it yet, but it was a very interesting case that went en banc, and you talk about things that are changing. It was same-sex female partners, both attorneys, and it went through in vitro. Obviously, only one woman can carry the baby, so the one woman was the biological parent. They had a contract that allowed that the non-biological mother was going to adopt the child upon birth. But of course, what happens? They break up before the child is born, because this is what happens in family law cases. And so now, what are the rights of that non-biological mother, the mother who paid for everything and went through in vitro with the other parent, who had every right and thought she was going to be raising that child together, picked sperm that was similar to the other mother. So, and now what happens? And so it's a very interesting case. It was a Philadelphia case. The trial judge ruled based on contract law that the other mother had the rights, and now it's before our court. So you will have to wait and see how we rule. It should be out hopefully soon. Another case, which was a case of first impression, which came from the Supreme Court, which was a custody case, and I thought it was really unique because it was a case that issued a gag order, and it's certainly not something that you often see in family law cases. And so it was a case where father was awarded sole custody, but there were some issues and allegations of sexual abuse by the father, which were completely disputed and found not to be credible. And mother's attorney held a press conference online. This is the other thing. Social media is now coming into play in every area of the law, but in family law, all the time. And so he went on YouTube, didn't name the child, but named the mom, named the child's best friend. And so it doesn't take a lot to put together. And the child went to a very small parochial school. So needless to say, it was very easy for anybody to identify this child. And so the judge issued a gag order and said you can no longer talk about this child, the child's emotional well-being, and the Supreme Court upheld that. And so that was a case of first impression, and it was very different because not so often do you see gag orders in a custody case. Another interesting case, which was just this year, also went to the Supreme Court from our court, which was a support case. And what our court did, and we were affirmed by the Supreme Court, was overrule the trial court in a case where, again, these cases also are like a little soap opera. That's why I kind of like doing the family law things. They certainly never bore you. Never bore you. You read the facts are juicy, and it's like, is this really someone's life? But it is. But it really does allow us to never get bored. When we read these family law cases, they're interesting. And here, mom and dad were never married. They had a child, and they broke up when mom was pregnant. Mom moved on to another relationship, and that father acted as a stepfather, was never a stepfather because she never married that man either, and mom died. And so now we have not really a stepdad, but was a stepdad, raising the child, and now the child went to go live with the biological father because mom is now deceased. Father, biological father, allowed so-called stepdad to see the child when he wanted. Well, that wasn't good enough, so almost stepdad filed a complaint for custody. And so then that child got custody. The child had the right to see this almost stepdad and had partial physical custody. And so then biological dad filed a complaint for support. Because if you want to actually act like you're the step-parent and have custodial rights, then you should pay support. And because you're holding yourself in loco parentis. And so the Supreme Court, we said that the trial judge was right in doing that, and the Supreme Court agreed. And so, you know, the argument was obvious that I'm not the stepdad. I was never even married to mom, but the Supreme Court felt that if you hold yourself out and you take that extra level, that you should also have to pay support. So they're just two little interesting cases, but I think what they both show is how family law is evolving. It's evolving with social media. It's evolving with who exactly is a family. It's evolving with how you have a child today. And so it makes our job very interesting, very difficult, but I just want everybody to know that we are mindful of the fact, and that's why they're fast-tracked, of the importance of these decisions coming out quickly. So, thank you.
Thank you very much. Our next speaker is Judge Megan Sullivan, who will be addressing motions that come before the court.
Good afternoon, everyone. Is that on? Is that working? Yep. Okay. Good afternoon, everyone. Thanks for coming out. This has been a great program put together by the PBA, so I really appreciate. I've learned a lot here as well. As the rookie of the Superior Court, I was given the plum assignment of doing appellate practice in motions area.
I just want you to know that it was President Judge Piniella who selected that.
But during the meeting that we discussed all of our, all of our assignments, PJ Piniella, always being the neutral arbiter, said, hey, if you guys want to exchange subject matters, just feel free to do that. So I thought, well, I better hold off for a couple of days because I'm sure I'm going to get lots of calls to do the motions piece of this. But when the calls weren't coming in, I started to think about what I was going to present as for tips on appellate motions practice, and I thought, wow, the interlocutory appeals, right? There's so much jurisprudence in there. It's so deep and rich and tangled, right? And then I sent an email to PJ Piniella and I said, hey, when are the PowerPoints due, and what do we have to do, and who do we have to hand them into? And he said, Judge Sullivan, you have 10 minutes. I was like, oh, okay. Well, I guess I'm not doing interlocutory appeals. So when I started to think about it, our first line, our first filter for motions practice, appellate motions practice, is the CLS department. And they do a wonderful, wonderful job of researching a lot of these issues. And I thought, well, in 10 minutes, I better get some pointers that these gals and guys see every day. So that's what I did. So with a couple of the CLS practitioners, I just kind of put together a general practice tip area, and it was great because I got a 5-page it was called Pet Peeves of the CLS department to just let you know how to sort of what kind of issues come up consistently and how to help avoid a lot of the pitfalls and not get your case sort of kicked out. So there's only 2 really big bodies of law or rules that you have to look at. Obviously the PA rules of appellate procedure. There's at least 5 rules dealing with motions. There's Chapter 13, which is the interlocutory appeals that I really wanted to talk about. Chapter 15, which is governmental determinations, and Chapter 16, which is the petitions for specialized review. And the one issue that constantly comes up in that area is sort of bail appeals. That is the one area that Chapter 16 deals with that comes up consistently. There's also our internal operating procedures, and if you guys didn't know this previously, it's published in 210 PA Code Section 65, and you can just go to the website pacodeandbulletin.gov. The internal operating procedures that deal with motions are 65.21 to 65.26, deals with all the motions practice. And generally, it's broken down into, we have single judge motions, and then we have motions panels. The single judge motions generally deal with housekeeping matters such as extensions, corrections or supplements of records, things that can be turned around rather quickly and don't need a lot of deliberation because they're rule-based. The motions panels, however, they require three judges on the panel, and basically it's all about jurisdiction, whether your case can come in or whether it's going to get kicked out. Motions to quash, motions to dismiss, and also motions for appellate review, like interlocutory appeals. In 2022, just to give you some data, there were approximately 5,254 single judge motions decided, and as of August 2022, there were 362 motions to the panel, the panel motions. So, we're dealing with a lot of motions on these cases on top of our already, as Judge Lazarus, explained, a really heavy docket. So when we decide those things, we do rely heavily on CLS to help us with case law and rules. So be very nice to them. They say when you call in, sometimes people can be not so nice, but be nice because they're our first line and our first filter. The first pet peeve, or the first let's be cognizant of what occurs, is that every lawyer thinks their case is an emergency and needs to be decided, but there should be some sort of an emergency etiquette because not every motion is an emergency. The definition of emergency according to CLS is it has to be a life or death scenario. And the one individual I spoke with the most, who's been there for more than a few years, said there has been one true emergency in her years at CLS. And that was a COVID case where there was an administration of, a court order about the administration of ivermectin for a patient who was dying of COVID. And that doctor did not have staff privileges, and so this order went back and forth. That was the one true emergency. What is not an emergency is your request for extensions, not an emergency. The evictions, my client's going to be evicted tomorrow. They had at least 30 days notice. So that's an emergency that you've now created and is not technically an emergency. Sheriff's sale is tomorrow. Again, lots of notice before that happens, right? So that's a self-created emergency. Emergency stays, they're dealt with by the PA rule of Appellate Procedure 1732. One of the things that has been indicated is a mistake that happens again and again is that those motions for emergency stays have to go to the trial court first, okay, and just be decided by trial court. And then, an emergency stay is filed with us, and then there's no information about what happened at the trial court. So either you didn't file one, which would be the wrong process and procedure, or you should have told us what happened at the lower level and attach the order to your emergency petition. Expedited is something that is much more accepted on when you're doing your emergency petitions, and an example of expedited orders is like family In family court, the custody over the holidays, that happens a lot, that comes up a lot. That many times has to be expedited. So expedited is probably the better word to use instead of emergency. So that's my shout out to CLS and asking everybody to be kind and not call everything an emergency. The other thing is docketing statements. So under the rule of appellate procedure 3517, there shouldn't really be extensions, is what was portrayed to me. You should just get it done. There is case law out there, I promise, that says you do not waive any issues by missing an issue on the docketing statement. Promise. It's Dixon versus Northwestern Mutual. Look it up. So just get those 2 or 3 pages filled out and get it back in time to CLS so they know sort of how to handle and we can move on with the appellate process. The due dates for docketing statements are not extended merely because you have a stay or outstanding motion. So get it in, even if you have other motions outstanding, just get the docketing statement in. Because you don't want your case to be dismissed because you didn't fill out a 2 or 3 page, basically, information from the lower court. Filing deadlines. CLS indicated that you really need to pay attention, especially in the area of deemed denials. So in post-sentence motions in criminal, if it's not decided within 120 days, it is automatically deemed denied. You have 30 days from that day to file your appeal. So not every clerk of court's office in every county will issue an order and tell you, hey, by the way, that 120 days is up, it's deemed denied. It just doesn't happen. And you don't want to lose your appeal rights just because of that. So when you're working on the appeal, just write in what 120 days from the post-trial motion is, and then you have 30 days from there. The other is the interlocutory motion certification. So you have 30 days, the trial court has 30 days, or it's deemed denied. Again, tick that off in your calendar because you don't always get a tip-off as to that, and you don't want to lose on an interlocutory appeal. You have 30 days from that 30th day to file it. So that's a tip. And then for all the criminal practitioners in the room, you have the Anders and Turner-Finley briefs. Those are a big issue, and a lot of times there's a lot of unnecessary work that has to be done and take it down to the trial court and back up because under Anders and Turner-Finley, you have to have 3 things. One is the Anders-Turner-Finley brief or the no merit letter, depending on whether it's a PCRA or a direct appeal. You also have number 2, the petition to withdraw as counsel. That has to be in there. And third, there needs to be a letter advising the appellant of their immediate right to obtain private counsel or proceed pro se. All 3 of those things need to be there for both appeals where you are filing basically a no merit. And a lot of times all 3 don't get put in there, and then they have to go back and do a lot of work. If you're filing this brief, you want to be out of the case, so why postpone it? So those were the 3 things those were the 3 areas that I picked out. There were others, but sort of just motions tips for everybody filing in the appellate court. Thank you.
Thank you, Judge Sullivan. And finally, our last speaker is Judge Carolyn Nichols, who will be discussing wiretaps.
Wiretaps, the topic. Is anybody here that practices criminal law? Tough crowd. Two people. Okay. All right. So the Superior Court Wiretap Authorization Authority, which is in your materials, so your eyes don't glaze over, you can look it over, is based in Section 5708 of Title 18 of the Wiretapping and Electronic Surveillance Act, and it authorizes the Office of the Attorney General or their designee or the county district attorneys or their designees to apply to the Superior Court for an order authorizing their interception of a communication. That communication could be an oral communication, an electronic communication or a wire communication. And the purpose of the interception is for the law enforcement agency to conduct an investigation of suspected criminal activities, to obtain evidence of commission of certain enumerated offenses in the statute in Section 5708, as well as providing evidence aiding in the apprehension of perpetrators involved in these crimes. And there's a whole litany of crimes, which could be drug crimes, crimes of violence, fraud, improper influence of political activities, robberies, a whole list of crimes and offenses which are too numerous for us to go into. But for purposes of this group, it's important to understand that the Superior Court, before 2018, the Superior Court published guidelines concerning Superior Court wiretap authorization applications, which can only come from the Attorney General or his designees or county DAs and their designees. So it's a small community of people that this would apply to. But these procedures were within our internal operating procedures. In 2018 and in 2020, there were significant amendments to Section 5708. So our court, in kind of looking at the best way to make the information more available to the public and communicating with bar associations, determined that instead of having the guidelines just in the internal operating procedures, that would be more widely available if that information was in Chapter 35 of the Rules of Appellate Procedure, so that the public, or certainly defense counsel, or the public at large could see what these procedures are and what the standards are. So currently, instead of the internal operating procedures of the Superior Court, the Superior Court wiretap authorization application procedures are in Chapter 38 of the Rules of Appellate Procedure. And their primary amendments from 2020, which are in your materials, which I won't go through the litany of it, but it deals with the application process, affidavits, contents of affidavits, and so on that are relevant to obtaining the authorization and what the process is and what the procedures are. But for the general public, or certainly those that are involved in these cases and defense of these cases, Chapter 35, the Rules of Appellate Procedure, one can review those procedures and see how to challenge the process should that become relevant. So I'll stop there since only two people here that might do this kind of process. So short and sweet. Thank you.
Well, thank you. I cannot believe that we actually finished with the judges' portion with 10 minutes. Amazing. I lost my bet. I did.
All right.
So we do have another portion of our program today, and that is to hear attorneys' perspectives. So we do have a little bit of time here. If you all, it's John Hare, Carl Myers, and Maureen McBride. If you want to come up to the podium and maybe discuss, appellate attorney's point of view. And then we'll finish up. So you have, with 3 people, 7 minutes, because then I have to say my thank yous.
Since I'm in the room with a bunch of Superior Court judges, I feel reflexively like I have to say, good afternoon. My name is Carl Myers of Stevens and Lee. I'm representing the appellant, and I'd like to reserve 1 minute for rebuttal. But actually, for everybody's benefit here, you'll be happy to hear that the 3 of us, we've decided to go with expedited argument. So it's not standard argument, so we're going to stick to 10 minutes. So we're going to be very brief and very quick because we realize we're the thing that's holding you from a glass of wine, and we'll be very brief. But since, and the Phillies game, yes, which it pains me to have to listen on the radio on the drive home. But in any event, since we're celebrating the court, we thought it was really important to emphasize just how important this court is within our system of justice. It's kind of been alluded to today, but we really haven't hit it hard enough. This court is often the last stop in most cases. In 80 to 90% of cases in Pennsylvania, The Superior Court has the final word in so many areas of law. And it's really important to emphasize just how efficient it is in getting to that result, in carrying out its mandate. It's often referred to as the busiest appellate court in the nation, and that's actually true, but let's put some quick numbers on that. We in Pennsylvania, we're kind of used to the Superior Court being efficient and getting its work done, but let's compare it to other states. This court disposes of 5,200 in a usual year, 5,200 merits decisions per year, and does it with 15 commission judges and a few senior judges. And we pulled some numbers. Really, John and Maureen did it, and I'm just going to take the credit for it. But in other states that dispose of about the same number of cases do it with many more judges. New Jersey, which decides about 4,200 cases a year, does it with, and these are similar appellate courts, so intermediate appellate court, as of right, general jurisdiction appellate court. New Jersey does it with 35 judges. Illinois does it with 52 judges. Louisiana does it with 53 judges. Ohio does it with 69 judges. And Texas does it with 80 judges. So we are an outlier in that we have a court that carries out its mission, writes a written decision explaining to the parties, to the trial judges, to the Supreme Court, what the court decided and why, and does it with very limited resources. So thank you, court, for working as hard as you do, because if you do the math, they're issuing an opinion a working day. Think about that. Think about that. So thank you.
Good afternoon, everyone. I just want to say thank you to Judge Pennella and Judge King, who put so much effort into this presentation today. I just want to talk very briefly about the things I appreciate about the Superior Court. I know a lot of you have appeared in front of them, but the statistics that we went over in preparing for this are astounding. I mean, we all know as lawyers how hard we work, but it's incredible to see that the workload that these judges have. I'm always appreciative, and I really applaud the court when you hear oral arguments and you see how the court has to go from a criminal case to a family law case to a contract case. I mean, it's amazing the different areas of law and the knowledge that the judges have about the facts of each case. So I appreciate that. I appreciate the fact that the court allows oral argument in almost every case. A lot of courts don't do that. Certainly the Third Circuit doesn't. And it really makes a difference, especially when litigants appear and they're there and they actually get to see the judges hearing their case. It's an incredibly valuable thing that the court allows. And so I appreciate that. I appreciate the fact that the court takes the show on the road and goes into different counties and gets to meet people. I mean, we've had, in Chester County, our Bar Association has had a reception afterwards, and it's really great for people who don't practice appellate law to get to meet these judges in their own location. I appreciate that the fact that the court grants re-argument. Judge Pennella has said that other states, very rarely do that, and so we have that ability here. I appreciate the fact that the judges are willing to do CLEs and to come into different locations to do that, are involved in the end of court, and have been very generous with their time in teaching people about what they do. And then finally, my last point is just I appreciate the compassion and the humanity. When I'm in oral argument and I see a pro se litigant get up and argue, the judges could not be more kind and more compassionate and willing to let those people have their day in court. So I appreciate that as well.
And I appreciate the high podium. This is nice. I'm going to echo what my friend said, and also I'm going to channel Justice Stevens and say when you're the last speaker, your main job is to be quick. So I want to really, since we're at the end of the symposium, I thought it would be appropriate to remind everyone of a tribute paid to the future judges of the court back on the last day of the last century, December 31st of 1999. Then President Judge McCune wrote a foreword to a book that was done in the court's first century. And he said a lot of really interesting things that I thought would be appropriate to close out the symposium with. And he in part looked back at the history of the court, but he also looked forward to the challenges that he knew you all would face in the future. And his words are really heartfelt, and frankly, they're prophetic. So I just thought I'd read a few of them. And he closes them with what he calls a wish and a prayer to you all in dealing with, again, these challenges that he knew were coming. So he said, "The court has always been an eloquent voice of the jurisprudence of reason." He said, "The jurisprudence of reason would wisely be a goal of the judges of the Superior Court during the 21st century, for they are certain to encounter challenges posed," and this is interesting, "for instance, by a technology of such speed that each day is a new age, and by an artificial intelligence uninhabited by conscience." How prophetic is that, given what's going on in the world? And as I said, he closed his tribute with what he said is a wish and a prayer for the court. And he said, "The wish is that the court's remarkable history will well serve you as a guide to the future, and the prayer is that your success will be equal to his wishes." So as we as practitioners reflect from the outside on what the court has done in dealing with a hopefully once in a century or two pandemic, getting its oral arguments up and running faster than any of the other courts that we've dealt with, keeping its caseload current, avoiding the backlogs that so many courts nationally have had, dealing with emerging technologies. Judge Stabile earlier mentioned browse wrap and click wraps and these things that I don't know anything about, but Judge McCaffrey in the court in writing the Chaluti decision knew about them. So, you know, it seems that if we reflect on Judge McCune's wish, this court has continued to meet the challenges and does so on a daily basis with all the emerging technologies, and that's just technology, with all of the other issues that the court confronts regularly. It's a really, really job well done, and 125, 128 years in counting, and certainly it seems that the court, from our perspective, certainly is very well prepared to continue for another century or two. So just really happy to be here, and thanks for allowing us to sort of crash your party. We appreciate it.
So this actually concludes our program, but I do have to give a shout out, so just bear with me for a minute. I do need to thank the Pennsylvania Bar Association with greatest gratitude for helping us facilitate this symposium. I also want to thank Maureen McBride, Carl Myers, Stacy Thomas, and John Hare as well. President Judge Piniella, this was an honor and a privilege to work on this with you. It was an honor to introduce retired judges. These are people in my career that I looked up to. And it was an honor to also be able to serve with some of them, just as it has been an honor to serve with all of you. So thank you very much for the opportunity to do this. And with that, this concludes our program, and a sincere thanks again to the PBA, and they have graciously agreed to provide a reception immediately following, and you don't have to go far, it's right out these doors. So thank you again, I appreciate it.